Silence, all stand. May now be seated.
Yes, Mr. Stolzer.
Commissioner, before I call my first witness, there are some appearances and there may be some other housekeeping matters.
Yes. Well, yes, Mr.
Commissioner,
Chairman.
morning. I appear for Mr. Shorten.
Commissioner, I appear now for Mr. Millam.
Yes,
Mr. Moore, previously representing Mr. Millam, is engaged elsewhere at trial.
Thank you, Dr. Hanscom.
Your Honour, please.
Commissioner, I seek authorisation to appear for Mr. Sass.
Yes, that's granted, Ms. Hogan-Doran.
Thank you, Commissioner.
Any other appearances? Yes.
Commissioner, the other matter to which our learned friend Mr. Stolzer was adverting was a matter I raised with him very briefly before you came onto the bench. It relates to the expected testimony today of Mr. Stephen Sass and the questioning which took place back in July, it is now, July 9, of Mr. Shorten in the Commission when he gave evidence relating to the Tees John Holland matter. I think you, Commissioner, you'll have some recollection of that, although I'm sure you've heard a lot of evidence since. Now, Mr. Shorten is concerned as a result of what has come to his notice and the notice of his legal representative subsequently, that he has not been afforded procedural fairness in that process. We withdraw that. Mr. Shorten's solicitors wrote to the solicitors for the Commission who reject those assertions and in effect stated that we should explain our position before the Commission this morning, and we seek to do so now. We're mindful of the fact that the Commission has a fairly demanding timetable, and we'll try and deal with this relatively briefly, but we do wish to deal with these issues now, if we might.
Certainly.
Commission pleases. To assist in this process, could we just provide the Commission, our learned friends, with some folders of some correspondence between solicitors for Mr. Shorten and solicitors for the Commission? I think Mr. Sass is actually in the hearing room because I'm told that he is to be the first witness. He was formerly a General Manager for Human Resources and Industrial Relations Safety with John Holland, and his evidence, we expect, will touch on matters about which Mr. Shorten was examined. A convenient exposition of the concerns, Commissioner, can be found behind tab 10. I don't know, and I'm not going to ask how much of this material you have seen, sir, but I propose to take you to it. There is this letter.
Also, I don't have to bother with tabs 1 to 9, is that right?
I'll take you back to those because the correspondence behind those is referred to either in this letter from Mr. Shorten's solicitors to solicitors for the Commission or in the Commission's response of the same date. And both those pieces of correspondence contain, it might be said, both heat and some light. The point under discussion is the questioning of Mr. Shorten on the 9th of July, and it was regarding an alleged agreement in the context of EBA negotiations said to have been arrived at between the joint venture, Tees John Holland, and the AWU for a payment to the AWU of some $100,000 per annum over 3 years. Commissioner, at that time, no statements or evidence had been provided to Mr. Shorten or his legal representatives by persons claiming to have any knowledge or involvement in those negotiations on behalf of Tees John Holland. And if I can invite you to go to the letter from Arnold Bloch-Liebler on behalf of Mr Shorten. Commissioner, you will see that the first reference there is to the Commission's letter of the 25th of September 2015, in which ABL, that is Arnold Bloch-Liebler, was advised that the Commission required notification of the persons that Mr Shorten sought leave to cross-examine by the 6th of October 2015, and what was described by the writer as the Commission shutout date, and it refers to the fact that there was some confusion arising from Practice Direction 12, which set out an earlier cross-examination shutout date. That letter, Commissioner, can be found behind tab 2. And for present purposes, we direct you, Commissioner, to the statement, first of all, of the dates upon which the evidence in relation to the Teeth John Holland matter would be heard. That was the 12th and 13th of October. The documents that would be the subject of examination were identified as those documents placed into evidence before the Commission during the hearings the Commission conducted between 28 May and 4 June and 8 and 9 July 2015. And there was a listing of those documents which included Shorten MFI 1 to 14. There was an indication that additional witness statements, private hearing transcripts and documents would be uploaded to the AWU October 2015 court book. That's at about point 3 on page 2 of the letter, Commissioner. From Friday 25 September 2015 onwards, there was a reminder or an emphasising of the confidentiality provisions of Section 6D(3)(b) of the Royal Commission Act, and there was a request for notification by the 6th of October 2015 by parties who wish to cross-examine a witness and the topics about which they wish to cross-examine that witness. Self-evidently, at that point, there was no listing of witnesses to be called. And just to clarify what the confusion was, there was an attachment of a practice direction signed by you, Commissioner, on the 25th of September 2015, which at paragraph 5 at least made reference in the last sentence to the need for applications to be made in writing no later than 2 October 2015. Nonetheless, it's accepted, and I think agreed between the parties, that 6th of October was the relevant and operative date. On the 1st of October, Mr Shorten's solicitors wrote to the Commission, and you, Commissioner, you will find that correspondence behind tab 3. It's actually an email, and a number of things were sought in that email. In the second major paragraph, this was said, although Mr Shorten has previously made this point, the Commission should provide all additional statements and documents which concern Mr Shorten, including long-held transcripts of private hearings, as soon as reasonably possible before the Parliament resumes sitting, so we may obtain his instructions. There was then a reference today to materials. Sorry, withdraw that. There was a reference to materials received that day, that is uploaded onto the website, which apparently were transcripts of private hearings which had taken place as long ago as the 15th of April 2015 in relation to a Mr Lance Wilson, but up to and including the 19th of August 2015, and an explanation was sought for the delay in providing those documents. What was also sought was, in view of the fact that no witness list had been advised, a request was made for a proposed witness list, and indeed the dates that those witnesses were proposed to be called as soon as reasonably possible. The document went on to say, significantly, there has been much media reporting of the fact that the Commission has made a decision to call Mr Sass and that his evidence may concern Mr Shorten. Mr Shorten and his lawyers have not been told by the Commission that the Commission intends to do so. If the Commission has previously decided to call Mr Sass, can you please let us know when it proposes to do so, and can you please provide us with a copy of his statement or transcript of his private hearing? That night, and you're on, Commissioner, you'll find this document behind tab 4. This ECB notification appeared, and advice was given to the affected parties and their legal representatives. Pardon me for a moment. Can I have you got the identify Mr Sass?
Can I just ask a question, if it's
Yes.
not inconvenient to your train of thought? It may not matter much, but the letter from Mr Zvaya, Thursday 1 October, was emailed at 9:34 p.m. Do we know when the document behind tab 4 was generated? In other words, was it before 9:34 or after 9:34? You said it was that night.
The document that I want to draw your attention to was, or that advice was at 11 o'clock that night, 11 p.m.
Thank you.
And the advice, and we're just anxiously looking for it at the moment, is not that which sits behind tab 4 at the moment, and we'll find the copy and hand it up to you. But I can tell you, as Mr Zwaya's letter of the 8th of October says, Commissioner, if you go to page 2 at about point 3, under the heading SAS statement provided 11 p.m. on 1 October 2015 to Mr Shorten. Later, about 11 p.m. in response to my email, and on 1 October 2015, the Commission made available, amongst other AWU evidence, the statement of Stephen Sass, dated 7 August 2015. The Commission did not provide a copy of the transcript of any Sass private hearing.
And what you've just read was from what?
I missed your question, I'm sorry.
You just read out a few sentences. What were you reading from?
I was reading from Mr Zwaya's letter of the 8th of October behind tab 10 of the folder at page 2, and under the heading SAS statement provided 11 p.m. on 1 October 2015 to Mr Shorten. Now, regrettably, it seems we've put the wrong notification in, but for present purposes it may not matter that much. What it referred to was the statement, or indeed a background document of Mr Sass, which of course was not a transcript of a private hearing or an interview, which subsequently emerged. But what was included, or reference was made, however, to, and I apologise for the pronunciation, but what was included was a transcript of the private hearing of Mr Resnawicki and attachments, relevant attachments for him. So that was at 11 o'clock, 11 p.m, on the night of the 1st of October following Mr Zwire's letter. On the 2nd of October, solicitors for the Commission just pardon me. Commissioner, if you go to tab 5, you'll see the response from solicitors to the Commission to Mr Zwire's 9:33 p.m. letter of the 1st of October 2015. Indeed, email. Thank you for raising these issues with us. Unfortunately, with the Commission's current reporting deadline of 31 December 2015, there is limited flexibility to reschedule a 2-week hearing block and allow a sufficient period for written submissions. The letter went on to state there had been no delay in providing affected parties with material relevant to the next round of hearings. A reference was then made to the Practice Direction 13 of the 25th of September, and went on then to explain that the Commission is entitled to keep evidence confidential until it determines that its publication will not interfere with the integrity of other evidence it is gathering, or publication is otherwise necessary to afford procedural fairness. As an investigative body, the Commission assembles evidence and assesses its relevance to the inquiry being undertaken. It is only when that process is complete that the relevant material is provided to affected parties in the preparation for and conduct of a hearing. That is what has occurred this week. And at the foot of that page, Commissioner, you will see that a reference was made to the release of a statement of Mr Sass to the electronic court book at 10:58 the previous night. And over the page, 6th of October was confirmed as the deadline, and then this was stated in the second paragraph of page 2. We invite you to take a sensible and pragmatic approach to cross-examination. You are more than capable of identifying witnesses that may be required for cross-examination on a case-by-case basis as their statements or transcripts are made available. And then it went on to reveal, to deal with later witnesses. Now, notwithstanding the non-provision of what emerged later, that is the transcripts of the private hearing and interview of Mr Sass, which I will come to, as I've just taken you to, Commissioner, the letter invited Mr Shorten's solicitors to take a sensible and pragmatic approach to cross-examination. That was, we would submit, not unnaturally understood to mean that in relation to Mr Sass, that material that had been made available at that stage was the relevant material to the issues which were the subject of questioning by counsel assisting on the 9th of July. That is the alleged agreement in relation to the payment of $100,000 per annum to the AWU. Commissioner, you may recall that on the 9th of July, Mr Shorten was questioned in a way by counsel assisting, which suggested that he had been party, that is, Mr Shorten had been party to an agreement with Mr Sass for the payment of $100,000 a year by or on behalf of the joint venture to the AWU. As an example, and this was referred to by Mr. Zwire later in his letter, I don't ask you to go to this at the moment, Commissioner, but at page 123 of the transcript, at line 33, this is Mr. Stolzer asking questions of Mr. Shorten. Question, isn't this the implementation of an agreement that you set up in your negotiations with Tees John Holland representatives in respect of the EBA? That is an agreement, just to be clear, pursuant to which Tees John Holland would pay $100,000 a year plus GST for the life of the project. Just note parenthetically that it was being put that the negotiations were between Mr. Shorten and Mr. Sass, and that agreement had been reached in those negotiations. There are other references at page 133 of the transcript of the same day. Again, Mr. Stolzer to Mr. Shorten at line 11. And I want to be very clear about this, Mr. Shorten. Do you say that you had discussions with Mr. Sass or indeed anyone else during those negotiations about a proposal pursuant to which an amount of $100,000 a year plus GST would be paid at any stage? Mr. Shorten said, no, I don't remember that. I do recall, and he was cut off. You say you don't remember. Does that mean it might have happened and you forgot? Mr. Shorten explained he was going to go a little further and expand on his answer and what he did recall. And then at line 34, Mr. Stolzer asked this. Well, Mr. Shorten, really my question was, do you say that you had discussions with Mr. Sass or indeed anyone else during those negotiations about a proposal pursuant to which an amount of $100,000 a year plus GST would be paid? Mr. Shorten responded, I'm telling you what I do recall and the context in which I recall it. Also at 134, at the very top of the page, what was put in response to that answer from Mr. Shorten and the previous answers was this question at line 2, so you can't deny it. That is, inferentially, the agreement between he and Mr. Sass.
What line was that again?
Line 2 of page 134. In the event on the 6th of October, and you will find this correspondence, Commissioner, behind tab 6, on the 6th of October at 5:46 p.m, and we understand the 6th of October was the day after a public holiday here in Sydney on the Monday. At 5:46 p.m. by email, Mr. Zwire, on behalf of Mr. Shorten, wrote he made some comments about the reporting deadline. He asserted that it would have been more sensible for the Commission to schedule the AW hearings at a time when Parliament wasn't sitting, and nonetheless accepted that it's now no longer possible to reschedule the AW hearings. The letter went on to say, or the email went on to say, Mr. Shorten also accepts and has always accepted that the Commission may withhold confidential evidence so as not to interfere with the integrity of the Commission's work. And some comments about the obligations that Mr. Shorten had, and clarified that he didn't want special treatment. He simply sought procedural fairness. There's a reference to treatment of other parties. Reference further to the reading of some additional evidence in relation to, amongst other matters, the Tees John Holland matter, and then the email from Mr. Zwire said this: Mr. Shorten will take a sensible and pragmatic approach to cross-examination. As you've suggested, Mr. Shorten and his legal advisors appreciate that none of the additional evidence directly contradicts his evidence. However, Mr. Shorten seeks leave to cross-examine the Tees John Holland witnesses in relation to the limited issue of the negotiation of the Tees John Holland EBA and payments made by Tees John Holland to the AWA, and then effectively reserved Mr Shorten's position in relation to other case studies.
AWU.
Sorry, what did I say?
AWA.
Sorry, AWU. Thank you, Commissioner. That does have some relevance because of some comments that Mr Sass earlier made in his interview. But if I can ask you to go back to tab 10, Commissioner, and this is going back to Mr Zwire's email, and at page 2, under the heading "The Commission XXN," being an abbreviation for cross-examination shutout date, Mr Zwire noted that he wrote at 5:46 p.m. on the shutout date he'd written to the Commission about the persons Mr Shorten would seek leave to cross-examine, and noted that he would take the sensible and pragmatic approach that had been requested. After that election had been made, under the heading "The Undisclosed Further SAS Evidence," Mr Zwire observed that the Commission made available for the first time the SAS transcript of interview dated 29 June 2015 and the SAS transcript of private hearing on 7 August 2015. What you will see, Commissioner, tab 7, if you go to tab 7, is that evening, that is the Tuesday evening following Mr Zwire's letter indicating that, notwithstanding the adoption of a pragmatic and sensible approach, and at that time only being in possession of the so-called SAS statement or background statement, which I might say had been apparently adopted and signed on the 7th of August 2015 after Mr Shorten had given his evidence. That evening, after Mr Zwire had sent that notification to the Commission, there were then uploaded onto the electronic court book a number of items, but relevantly and importantly, a private hearing transcript, as it was described, of Stephen Sass, and a private interview transcript of Stephen Sass. That was the first that anyone acting for Mr Shorten, indeed Mr Shorten himself, became aware that there was any such hearing or interview transcript in existence. Page 3 of Mr Zwire's letter behind tab 10. This is the letter of the 8th of October. Mr Zwire asked, "Can you please explain why the Commission held back the first SAS interview and the SAS transcript until after the shutout date? The Commission, if it was intending to provide Mr Shorten procedural fairness, was obliged to provide it to Mr Shorten prior to the shutout date." We should just make the point, Commissioner, that although the private hearing took place after Mr Shorten's evidence, clearly enough, the transcript of interview was dated 29 June 2015 and it predated Mr Shorten's evidence on the 9th of July. The letter went on, "The first SAS interview appears to be the only record of SAS's statement in the possession of the Commission prior to Mr Shorten's examination on 8 and 9 July 2015. Please provide us with a copy of the entire tape recording of the SAS interview, as we seek to have it checked against the type version provided to us and tested to ensure its authenticity. And just pause there and say that one of the matters which was resisted was a query about the authenticity of the tape, and it's accepted that that sentence would have been better expressed to if it had read tested to ensure its accuracy. Mr Zwire went on, please let me know if there are any other recorded meetings with SAS or notes of the Commission's discussions with SAS, and if there are, please provide us with the transcript notes and tape recording of those discussions. And the same request was made in relation to other witnesses that Mr Shorten had indicated he wished to cross-examine. In the middle of page 3, Commissioner, there were a number of what I'll describe as paraphrasings of statements that had been made by Mr Sass in that interview of the 29th of June 2015. And without reading them all in detail, what Mr Sass said in that interview was that there'd only ever been a loose discussion with Mr Shorten about the joint venture paying for an organiser, that such an arrangement was never entered into with Mr Shorten, that Mr Shorten hadn't said that the organiser's salary would be $100,000, but it was Mr Sass putting 2 and 2 together to come up with that number. Mr Shorten didn't speak about a number of $100,000 per annum, that the payment of $100,000 per annum was never, ever agreed at the Shorten level at all, that Mr Sass had first learned about that payment paid by the joint venture to the AWU, as it is being put in these proceedings, when it was reported in the newspapers, and that Mr Sass knew there was no AWU organiser paid for by the joint venture. Now, just pausing there if I might, those were significant and relevant statements we would submit that had been made by and were known to counsel assisting and solicitors for the Commission before that questioning was undertaken of Mr Shorten on the 9th of July in this Commission. The letter from Mr Zwire continued under the heading Shorten Examination Unfair, and there was reference to one of the questions that I've already taken you to, Commissioner, and it was stated that when counsel assisting the Commission asked that question of Mr Shorten, he did so knowing full well from the first SAS transcript that this was not so. Certainly, what counsel assisting knew was that Mr Sass had said this was not so, and he was the other party to the suggested negotiations and agreement that was the subject of the questioning. Mr Zwire noted that the examination may have had other consequences, including an impact on Mr Sass, and may have impacted on the integrity of the investigation of the topic. I won't trouble you with the other concerns. There was a separate concern raised about advice to Mr Shorten's solicitors as opposed to other parties. I don't want to press that. And in conclusion, it was said on Mr Shorten's behalf that he had not been accorded procedural fairness by the Commission, and a request was made for provision of further evidence in a timely way and advice as to the likely volume of additional evidence the Commission intends to make available and what it is, so we may consider our position further, including whether we can deal with it. Now, we make no application in that regard in terms of our capacity to deal with it, but just for your information, Commissioner, we've done a quick calculation. At last count, since the 25th of September, something in excess of 10,000 pages of documents have been uploaded to the electronic court book in relation to these case studies relating to the AWU. No, I don't think so. Right. And I'm told, just to clarify that, that includes the HSU material, but doesn't include the material we already had in relation to the AWU matters prior to that date.
So it includes the HSU material, but not the AWU
Yes.
material
That was-
before 8 October
Yes. Before 25 September.
or 25 September.
Now,
But,
Commissioner,
it may not matter much, but what was supplied between the 25th of September and the 8th of October?
that was the quantity of
That
documents
was the
that I've just
10,000
referred
minus
to.
the HSU. That was the 10,000 pages in excess of minus the HSU material.
Well, including the HSU material, I'm
I.e.
told.
one notionally deducts the HSU material
Yes.
because
Yes,
Mr. Shorten's
Quite
not
so.
involved with the HSU.
yes, quite so. Now, Commissioner, we would submit that. I'm sorry, Mr. Soljas. Yeah. One of our concerns is that it would seem that that material was only provided to Mr. Shorten's solicitors when it became clear, or at least likely, that Mr. Sass would be questioned in this commission, and significantly would say, when one looks at the summary that has been set out in the middle of page 3 of the 8th October letter from Arnold Bloch-Liebler, the account given by Mr. Sass prior to Mr. Shorten being questioned was substantially in accord with the account given by Mr. Shorten when he gave evidence regarding those matters. Now, as you, Commissioner, observed when you, and I put this neutrally, intervened in the questioning of Mr. Shorten, it was on this very question at page 136 of the transcript of 9 July. And the relevance of taking you to this is to draw your attention to the comment that in our respectful submission was a fair statement in terms of the publicity. You said this: you, if I can be frank about it, have been criticised in the newspapers in the last few weeks, and I think it is generally believed that you have come here in the hope that you will be able to rebut that criticism, or a lot of it. I'm not very troubled about that, though I can understand that you are, and it is legitimate for you to use this occasion to achieve your ends in that regard. Of course, prior to Mr. Shorten giving his evidence and thereafter, it was being reported or speculated that Mr. Sass would be giving evidence and would contradict Mr. Shorten. That is, that he would give evidence that he had, that is, Mr. Shorten had negotiated an agreement for the payment of $100,000 over 3 years, which had been reached as part of the negotiations surrounding the EBA between the joint venture and AWU. Indeed, it was during Mr. Shorten's responses on that very issue that you, Commissioner, intervened and made certain statements about Mr. Shorten's credibility, which was widely, but I would suggest inaccurately, interpreted as a finding or a formed view adverse to Mr. Shorten's credibility. The same day, the solicitors for the Commission responded, and Commissioner, you will find that response behind tab 11. And it was strong in its defence. It unsubtly suggested that many of the allegations are either plainly wrong, offensive or defamatory. And then seriatim dealt with them. Firstly, we have rejected the assertion that your client has in some way been unfairly disadvantaged by the timing of the release of evidence, and went on to explain that for reasons that have now been twice explained to you and which you appear to have ignored, it's false to suggest there's been some delay in serving relevant AWU evidence on your client. And that was an email of the 8th of October referring, no doubt, to, amongst other things, the record of the interview of Mr. Sass in June of 2015, prior to Mr. Shorten's evidence. At point 2, it was emphasised that there was no shutout date, and stated that the principal date for notification was 6 October, but advised your client was at liberty to request from the Commissioner such indulgences as were necessary to ensure procedural fairness. That may or may not be so, but of course the language of the correspondence was that the 6th October was the deadline. At point 3, as regards the supplementary material concerning Mr. Sass, the context for the release of this material was clearly outlined in our ECB notification to affected parties on 6 October 2015. Mr. Sass's witness statement was released on 1 October 2015 because at that time it was assessed as sufficient to inform affected parties about the evidence Mr. Sass is likely to give. Over the subsequent weekend, the position was reviewed further and it was decided that, out of fairness to the parties, your client in particular, Mr. Sass's interview transcript and private hearing transcript should also be released. We fail to understand what genuine complaint you can have about that, particularly where your client had already decided that he wishes to cross-examine Mr. Sass. At 4, it was said that the allegations made about counsel assisting in the paragraph under the heading "Shortened Examination Unfair" are offensive, without basis and defamatory. For example, we draw your attention to the private hearing transcript of Mr. I'm sorry, the spelling's there, Rzesniowiecki, Resnowicki, on 30 June 2015, and page numbers were given, 8 and 9 of the transcript. Now that's the transcript of Mr. Resnowicki that was provided along with Mr. Sass's so-called statement of the 7th of August. And it was said that that demonstrated a proper basis for the examination of your client on the topic you raise. Your allegation should be unreservedly withdrawn forthwith. If not, your client's counsel should be in a position to address it before the Commissioner next week. At point 5, the request for the audio tape to test its authenticity, that was also said to be grossly offensive and also defamatory. It will not be provided, nor will any other notes or transcripts relating to other witnesses be provided. It was said that in the case of each witness, the Commission has provided to affected parties such statements or transcripts as are necessary to give fair notice of the evidence likely to be received from that witness. And then at paragraph 6, there was set out a number of separate matters under the heading we've substantially addressed your other concerns in our letters of 2 and 7 October. Could I invite you, Commissioner, to go to tab 14, and you will see the response from solicitors for Mr. Shorten by email on 9th of October 2015, addressed to Mr. Beaton. Thank you for your letter of 8th October. I deny my letter of 8 October 2015 is plainly wrong, offensive or defamatory. The first major paragraph suggested that the access that was sought to the audio tape, indeed the tape, was due to the fact that it appeared to be incomplete because the transcription commenced mid-sentence. Mr. Zwire conceded it would have been clearer if the letter had said completeness and accuracy rather than authenticity, but went on to press for the audio tape of the first SAS interview and all Commission notes and recordings of meetings or discussions with Mr. SAS prior to Mr. SAS being called to give his evidence and cross-examined. I should say that we understand that that is to occur first thing this morning. At least the first witness to be called this morning is intended to be Mr. Sass. Commissioner. Mr. Zwire sought information as to whether the Commission would reconsider its position by 5 p.m. tomorrow, Saturday, 10 October 2015. Have a response? Yep. And tab 15? Yes. No. Yep, that's all right. The other matter that was dealt with in Mr. Zwire's email of the 9th of October related to communications with other affected parties. Again, I don't need to trouble you with that, Commissioner. And then tab 16, you will see a response in relation to the request for the tape recording. This is 9 October 2015 from solicitors for the Commission, and it said, I'm informed by the lawyer responsible for recording the informal discussion with Mr. Sass on 29 June 2015 that the recording device was activated shortly after initial introductions and pleasantries, but before anything of substance was discussed, hence the incomplete transcript. The transcript reflects the extent of the audio that was recorded. That said, having regard to your concerns, the transcript will be checked for accuracy over the weekend and a markup of any corrections provided on Monday. We understand that is being done at present. There are apparently some corrections being made and 2 substantive changes to the transcript, and there's been a request made for that to be done urgently so that that can be provided to the parties. Thank you. Commissioner, what we wish to place on record is our objection to the process which has been undertaken, in particular the questioning of Mr. Shorten in the way it was conducted when the Commission was in possession of an interview with Mr. Sass, the purported other party to the alleged agreement, which denied any such agreement, in our submission, that process had the potential to unfairly damage Mr. Shorten's reputation. He is clearly entitled to procedural fairness in these proceedings. He's entitled to be fairly treated. There is an obligation, we would submit, to ensure that his reputation is not improperly or unnecessarily harmed. The rules of procedural fairness, we would submit in this regard, can be simply stated. The basic test is one of fairness. However one wishes to read Mr. Resnowicki's transcript, Councillor Sisting had, on this question, Councillor Sisting had available to him, even if you did not at the time, Commissioner, the transcript of Mr. Sass's private interview, which indicated that no agreement of the kind that Council was questioning Mr. Shorten about had been reached, and indeed there'd been discussions in only the vaguest terms about the employment of an AWU organiser on site. Leaving aside even Mr. Shorten's position, no one can gainsay the proposition that it is important that public confidence be maintained not only in the judicial system but also the exercise of quasi-judicial powers and in the integrity of royal commissions generally. It's our submission, Commissioner, that as a matter of fairness, before Mr. Sass gives his evidence, we should be provided with all records of meetings or interviews with Mr. Sass as specified in our or in Mr. Shorten's solicitor's requests of the 8th and 9th of October this year. Commissioner, because of the view we have taken in regards to other witnesses, we don't press at the moment that application in relation to other witnesses that Mr. Shorten has sought leave to cross-examine. Those are the matters we wish to raise, Commissioner.
One moment. Yes, thank you. Yes, Mr. Stolger.
I'll endeavour to deal with the points in response briefly.
Can I just try and encapsulate this? I'm sorry to interrupt you. What it comes down to, Mr. Cleland, is this. You have in effect made a protest and you have made an application, and the application is for the provision of all transcript, notes and tape recording of any meetings between Mr. Sass and the Commission or Commission staff.
Commission staff or Commissioner, yes.
That's your application? Yes. Yes, Mr. Stolger.
I won't endeavour to deal with all the points that my friend has raised, but I will have to address some of them. In his rather lengthy submissions, my friend has...
Just one slight problem. Not a word of evidence has been tendered.
No.
And no request, as I understand it, has been made for you to tender any evidence. What should we do?
Well, no. My friend may be implicitly suggesting that. The last item of correspondence merely said that Senior Counsel currently intends to raise these matters in the Commission. That was back on the 9th of October, and it appeared to be a much narrower matter. Of course, it's a very wide-ranging statements have been made this morning with all sorts of complaints. None of those were brought to our attention in advance, so my dealing with them will be somewhat foreshortened. But
Commissioner, can I just respond on the question of tender? We did want to tender the folder of correspondence, and
Yes, and?
And for the purposes of this application, we wanted to tender the transcript of interview of Mr Sass and the transcript of the private hearing of Mr Sass, in addition to the so-called statement of Mr Sass.
So it's the folder of correspondence, the statement and the interview transcript.
So you'll just to make sure that's understood by everybody, there is a private interview transcript with Stephen Sass that we have been provided, and it is that transcript that is being amended at the moment. But the current version of it we've been provided with, and that interview occurred on the 29th of June 2015.
Yes.
There is a transcript, Commissioner, of a private hearing at which you presided, sir, on the 7th of August 2015. Council assisting, Mr Stoljar. And we have also been provided with a document. This was the first of the SAS documents that was provided back on the 1st of October, and it's headed the Eastlink Project Industrial Relations Background and Payments to the AWU, and appears to have been signed by Mr Sass on the 7th of August 2015.
Yes.
I'm sorry to interrupt, my learned friend.
Well, Mr Stoljar, do you wish to... Are you going to tender all or any of those?
Well, it's not appropriate in my submission to tender the two transcripts, the hearing and the interview. They may or may not be tendered during the course of the examination this morning, but there's no necessity for them to be tendered on this application on any view, in my respectful submission. In terms of the correspondence, given that it's already been addressed in open court, in my submission that Your Honour should receive the bundle of documents on this application, the bundle of correspondence.
Well, the Arnold Block Liebler folder entitled Index of Correspondence from 23 September 2015 might as well be called Arnold Block Liebler MFI 1. And that leaves, I think, Mr Sass's statement provided on the 1st of October, signed in August. Mr Cleland mentioned four things, I think, the first of which was the folder, which is Arnold Block Liebler MFI 1. You, I think, have opposed the interview of the private hearing on the 26th of June 2015 being tendered, and also the transcript of the private hearing on the 7th of August 2015. But that leaves the statement of the 7th of August.
I have no difficulty with the statement of the 7th of August,
Right.
Commissioner.
Well, that'll be Arnold Block Liebler MFI 2.
The second of those matters, just for the record, I note, as I understand, is the 29th of June. It was the private interview. Commissioner, if it's convenient, it may be more convenient. It may be appropriate to mark the statement as SAS MFI 1, since I was proposing to tender it in a few moments in any event.
Yes, let me just... Well, the document that you have referred to does purport to have been signed on the 7th of August, and it'll be called SAS MFI 1.
May it please the Commissioner.
So there's nothing else that we need bother with?
No.
Right.
Can I just
What appears in the transcript of earlier proceedings in public, of course, are part of the record and needn't be freshly tendered. Yes. I don't think they've been
I am
identified.
No, Commissioner. And for my part, I am going to have to tender, just to respond to a couple of things that my friend has said, pages 8 and 9 of the private hearing of Mr Resnevecki of 30 June 2015.
Yes, well, the private hearing of Mr Resnevecki of the 30th of June 2015, pages 8 and 9, will be Arnold Block Liebler MFI 3.
No, please, Commission. Now, can I just deal with one other housekeeping? I'm
I
sorry.
think that I withdraw that. I think it should be Arnold Block Liebler, MFI 2. Now, you were saying one other housekeeping matter?
I just wanted to correct one thing that I just noticed appearing on the transcript. It may come up in due course. On the transcript as it came up, it seemed to be saying that none of the matters had been raised in advance. That's not correct. Some of the matters were raised in advance. I wish to simply say that, yes, some of the matters had not been raised in advance. Now, can I then come to what I wish to say in response to what Mr Cleland has said? The first general observation is that every effort has been made by this Commission from the outset to ensure procedural fairness. That has applied in respect of these hearings, and in our respectful submission, although generalised observations or complaints have been made, no lack of procedural fairness has been shown. Can I then come to some of the detail? My friend, with the greatest respect, seems to make submissions canvassing a wide range of topics, and it's not always easy to unpick what the precise issues or concerns are said to be. The first, though, that one seems to draw from what he said this morning was that there was some lateness in receiving both the transcript of the private hearing and the private interview. Two observations in response to that. The first is that my friend hasn't taken you or said very much about Mr Sass's statement of 7 August 2015, which has now been received into evidence. My friend has had this since the 1st of October 2015, and what that document says, among other things, is on page 3, for example, if you have it there, Commissioner, a high-level in-principle agreement was reached between Shorten and me in late 2004. There was some limited discussion, I'm looking at the second paragraph, limited discussion in relation to how the AWU would ensure that the workforce would become members of the AWU. These discussions included the possibility that the project might directly fund the costs of an organiser, salary plus car equating to approximately $100,000 per annum, but this was not finalised and the idea did not form part of the in-principle agreement. And there are further statements to similar effect in other parts of Mr Sass's statement. But the only point there being that my friends knew about this statement and knew that Mr Sass's position was, it would appear, as he'd articulated in the statement from the 1st of October 2015. That's the first point I wish to make. The second point I'd make in response to this complaint of lateness, or the documents were, to use my friend's rather dramatic phrase, held back, or the like, is that an explanation has been given in respect of this in the correspondence, and it's a very simple one. Tab 11 of the bundle of correspondence, at paragraph 3, says, as regards the supplementary material concerning Mr Sass, the context for the release of this material was clearly outlined in our ECB notification to affected parties on 6 October. Mr Sass's witness statement was released on 1 October because at that time it was assessed as sufficient to inform affected parties about the evidence Mr Sass is likely to give. Over the weekend, the position was reviewed further. It was decided that out of fairness to your parties, your client in particular, Mr Sass's interview transcript and private hearings transcript should also be released. We fail to understand what genuine complaint you have about that, particularly where your client had already decided he wishes to cross-examine Mr Sass. And in my respectful submission, Commissioner, no genuine complaint has been articulated. Can I indicate, and this will become relevant in due course when I come to the relief that my friend seeks, that this Commission's practice is not to disclose informal interview transcripts. That is not typically done. It has been done in this case because after review of that transcript, it was thought appropriate that affected parties Mr Cleland's client in particular should have access to that transcript. And that's why it was released, in addition to the private hearing. For the purposes, I might add, of ensuring procedural fairness. And with the greatest respect to my friend, how any complaint can be made about that is, we would say, unclear. And we would reject the proposition that there's been some lack of procedural fairness in relation to that release. And we say that phrases such as held back or shut out date or request to check authenticity of transcripts are not designed to facilitate the calm and rational debate that we might have about these issues. That's all I wish to say about those. Now, can I then come to the proposition which really occupied my friend's submissions at some length, although ultimately it was rather unclear where it went, save as, well, I won't say that, but it was unclear really where it all went. He said that there'd been some unfairness to Mr Shorten on the 9th of July because certain questions had been put to him which he said were contrary to the interview of Mr Sass. Now that's where I need to take Your Honour to pages 8 and 9 of Mr Resnevecki's transcript of private hearing. Because if one is going to delve into this,
Pause.
I can provide you with a copy,
Yes,
Commissioner, if
I
that's
don't think
what
I have
you
a
do.
copy.
Just grab a copy. This is where I indicated, Commissioner, one needs to try and unpick the different complaints. Complaint 1 seems to be a complaint about what happened between 1 October 2015 and today. Complaint 2 seems to be a complaint about what happened on the 9th of July 2015. How the two are interconnected is somewhat unclear, but in any event, for the purposes of considering fairness or otherwise of what occurred on the 9th of July 2015, one needs to, as it were, wind back the clock and look at what the material was available as at 9 July 2015, not what material may or may not be available as of today. As of 9 July 2015, the Commission was in possession of the following evidence, which I might add had been given on oath, not in some private and fairly informal interview. The evidence that had been given on oath was as follows, if one picks it up from line 9. Sum of 300,000 odd seems to have been paid by TIS or by the joint venture to the AWU. What was that arrangement? How did it come about? Mr Resnevecki says, my understanding of how that arrangement came about was that before I joined the project, there'd been some high-level discussions between the AWU and representatives of the joint venture parents, and the parties to those discussions were trying to set up a framework under which, you know, the industrial relations arrangements for the project would be put in place. And then further, I won't take you through every word, Commissioner, further down, line 27, my understanding, well, in fact, I'll pick you up from line 25. He says, talking about non-working delegates, and then he says whether there might be a more creative solution in place or put in place. He says, my understanding was that there was a sort of an arrangement, you know, agreed that the joint venture would provide resources to the AWU to assist them to be able to provide organisers to the project. That's how it came about. 32, let's go over that a little bit. First of all, someone told you that this had happened, that's my recollection. 38, who told you? I believe either Mr Sass and Mr Connell told me that, or Mr Sass only. And just tell me what was actually said to you about it, certain things. Top of the page, they say an agreement has been concluded. I don't recall exactly what was said, but that was my understanding. You know, thinking back, I believe there was an agreement around that. An agreement reached before December 2004. Yes, that's right. Who are the parties to the agreement? Do you know? Well, certainly Mr Shorten, probably Mr Mellom, so probably both from the AWU, and Mr Sass. Certainly Mr Shorten, probably Mr Mellom and Mr Sass. I'm not sure about Mr Connell and whether he was involved or in the development of that part of the agreement or not. You said it was to provide resources. What sort of resources? Financial. Was there a figure mentioned, nominally 100,000 a year plus GST? Who told you that? I assume Mr Sass. And then he goes on to talk about how organisers are paid, etc. And then then there were some questions about who knew about this arrangement. Now, so what that evidence given on oath was agreement reached before December 2004, party to the agreement, Mr Shorten certainly, probably Mr Mellom and Mr Sass, figure, provide financial resources, figure mentioned nominally 100,000 a year. And there's more evidence in the private hearing about that, but just for the purposes of this application and to rebut the suggestion that there was some unfairness, all I wish to do is tender those 2 pages. But perhaps I can say this, and had I had a bit more notice about this, I could have come armed with more detail. If you recollect, Commissioner, that the material that's in evidence already, from my recollection, it's in Shorten MFI 9, there was a long series of emails talking about the agreed sum and the like, and well, not a long series, but there were a number of emails talking about agreed sum and the like, and it's a reasonable inference that if there was some agreed sum, then there'd been discussion about when that agreement was reached, and the sworn evidence was that that was when the agreement was reached. Now, that comes from Mr Resnevecki. My friend says, well, it doesn't come from Mr Sass. Well, quite so. But having received that sworn evidence, one needs to put evidence of that kind to witnesses. And sworn evidence of that kind is the most valuable evidence which this Commission has, and if one has received evidence of that kind, it is, I would say imperative, but it is certainly appropriate to ask a witness about it, another witness about it, and that's exactly what was done. It should be remembered, Commissioner, that the interview of the private hearing of Mr Shorten was brought forward as his request. The public hearing was brought forward at his request and for his convenience. Had it been left till the original dates fixed, no doubt further private hearings could have been held and a more comprehensive set of sworn evidence could have been put to the witness, but it was brought forward and one had to deal with what one had to deal with. Mr Shorten had no less than 6 counsel, 3 senior counsel, 2 present in the witness room, and we would respectfully submit that he was amply protected, and persons were able to make whatever submissions they wished about the questions that were put. The questions that were put were in any event denied. He said he didn't remember anything about that matter, and he's been invited subsequently, as one has seen from this correspondence, that if he wishes he can put on any further evidence to amplify or clarify the evidence he gave. That invitation has been issued.
Just to avoid perhaps any misunderstandings, it would be technically correct, I think, to say Mr Shorten did not accept what was put to him.
Yes.
There's a range of theoretical possibilities: flat denial, pointing to extreme improbability, simple failure of recollection, but it's sufficient for present purposes to say that Mr Shorten did not
absolutely, Commissioner.
align himself with the propositions implicit in the questions put.
Yes. So in those circumstances, Commissioner, we would respectfully submit that the propositions advanced in our correspondence remain accurate, succinct and precise, namely the propositions which are set out, in this case at paragraph 4 of the letter at tab 11 on 8 October 2015. And nothing that has been said today in my respectful submission changes that. As to paragraph 5 of that letter, and that really is coming to the application that my friend really makes, the other points seem to be in the nature of it's it's unclear really why they're being ventilated this time, but in any event,
Well, he makes them simply as a protest. There is one application and there is
and a protest.
a protest,
Yes.
which has various limbs to it.
Well, I've endeavoured to deal with the protest, and in my submission, if we then come to the application, what I'd say about that is that my friend has received, unusually, not only the transcript of private hearing, but in addition, the transcript of the informal interview. There are some very minor, they were said to be matters of substance. As I understand it, they were very minor corrections to the transcript, but in any event, they've been made and they've been communicated to my friend this morning.
While he's been speaking.
No, they were... Sorry?
I mean, at least in the short run, I don't think it's necessary to get into a great state about it. If it is desired to change the transcript for some reason, whether or not those responsible for making the changes on the transcript have yet had time to do so is an immaterial thing. The question is, what are the changes? If they involve radical changes, then one's thinking goes in one direction. If the changes are of the character you've been summarising, then they go in another direction.
Well, an email was sent to my friend's instructing solicitor this morning at 9 o'clock advising that because of his complaint about the authenticity of the document, which has now been corrected to some extent, the tape recording was checked again. There were minor typographical errors at a number of pages, and what are described as two more substantive changes, which seems to be just the correction of certain words, which on my reading won't affect the substance of what was said in any way, but if anyone wishes to contend otherwise, they are free to do so. In other words, they're very minor changes.
Was that email received?
Well, as far as I know, it was sent. Well, I can clarify. Yes, it was received, yes, at 9 o'clock this morning.
Perhaps a copy should be tendered.
Certainly, Commissioner. I tender the email from the Commission to Mr Zwire of 9:05am of 12 October 2015.
That'll be Arnold Block, Legal MFI 3. Thank you.
So coming back to the application, Commissioner, we would respectfully submit that, as I've now indicated on a couple of occasions, the Commission doesn't have a practice of disclosing informal interview transcripts, only in unusual circumstances such as arose in the present case. That was done precisely to ensure procedural fairness. Reiterate the comment that's been made. We don't, with respect, understand what genuine complaint can be made when every effort has been made to give procedural fairness, including departure from usual practice. We are not aware of any rule of law or practice pursuant to which it's incumbent on the Commission to disclose any note or record of any discussion whatsoever to an affected party, presumably for the purpose of enabling that party to embark on a tour of the produced material in the hope of uncovering some note or point of relevance. And we don't propose, with the greatest respect, to embark on that exercise here, and don't propose to accede to the application that's been made. Can I just reiterate, Commissioner, that the letter that was sent by the Commission's solicitor on the 8th of October, expressing the position in some detail,
Just one moment.
which is at tab 11. Oh, no, I'm sorry. Yes, tab 11. Made quite a number of detailed points. The only short response that was received was that behind tab 14, which merely says, which corrects the point about accuracy of the transcription. It says, my client requested access. There's a concession made that it would have been clearer had the letter said completeness and accuracy, and presses for the audio tape or videotape of the first SAS interview and all commission notes and recordings of meetings or discussions with Mr SAS prior to Mr SAS being called. That's in substance, as we read at the application. Then says you also refer to the ECB notification to affected parties. That's really a topic that hasn't attracted any attention this morning. And then it says at the end, Senior Counsel currently intends to raise these matters in the Commission. Now, a natural reading of that was that these matters are those which are adverted to above, which is the application. In fact, what's happened this morning is, without notice of any kind, a protest has been made complaining about conduct back in July. My only point about that is to say that I've endeavoured to respond to that as best I can on the run, but it may be that some further points could reasonably be made, and if so, they'll be articulated in correspondence. And just coming back to the application, one final point, there is no submission being made that there are any relevant inconsistencies between the private hearing and the statement, etc., on the part of Mr SAS. In my submission, that could be relevant to the question of whether or not the application is acceded to. Other than that, those are my submissions. May it please the Commission.
Yes. Dr. Hanscom, do you have any submission you wish to make?
We would seek to reserve our position at the moment on these issues. If any of them do touch upon I'm sorry.
It's a little hard to hear.
Try to shout.
Thank you.
We would seek at the moment to reserve our position on this issue. To the extent any of these issues touch upon Mr Millam's position, if that becomes apparent, I hope that you will entertain a submission on a relevant issue.
Yes, if on the condition you've stated, I'll certainly entertain anything you have to say. Thank you. Ms Hogan-Doran, do you have anything you wish to put?
I do not wish to be heard on the merits of the application. However, through you, portions of the transcript of the private interview have been read onto the record. I was just going to inquire as to the non-disclosure aspect of the previous order that had been made concerning that document.
You say that that some parts of the private hearing have been read onto the record.
Yes.
And you're concerned that that may collide with a confidentiality order or the order for the private hearing.
Yes.
Now, has that order been rescinded, do you know, Mr Stolger?
It hasn't, Commissioner. And Ms Hogan-Doran may be adverting to, for example, the passage that my friend read out from the letter from page 3 of the letter at behind tab 10 of the bundle.
Now, that's the first SAS interview.
Yes.
This is the trouble with definitions, well-meaning though people are who employ them. We have to search back. What is the first SAS interview? Is that the one?
That's the 29 June 2015 interview. It's caught by confidentiality order because it's on the electronic court book. That's how my friends have access to it.
Well, is there any objection to the material that Mr Cleland read out being treated as non-confidential?
Not on my part, Commissioner.
Very well. I so order. Ms Hogan-Doran, thank you for drawing it to our attention.
Thank you for that clarification, Commissioner.
Yes, Mr Cleland.
Commission pleases. Commissioner, can I take the last point raised by our learned friend Mr Stolger first? In respect to the private hearing transcript of Mr Sass, it might be more a question of what is left out of that transcript or Mr Sass's answers But self-evidently, we don't know what evidence Mr Sass is going to give before the Commission this morning. Secondly, if I can move to the questioning of Mr Shorten by counsel assisting, what's fallen from our learned friend this morning with respect does not assuage our concerns about that procedure at all. We don't understand Mr Stolzer to be suggesting that Mr Sass was untruthful when he took part in the interview on the 29th of June. He was asked a series of questions to the point where all those in the interview with him asked each other at the end whether there was anything else, and they all concluded that they had no further questions. There is no basis identified by Mr Stolzer as to why he would doubt the accuracy of anything that Mr Sass said in that interview. What he, with respect, proffers, and proffers unconvincingly in our submission, is the suggestion that Mr Resnicki gave sworn evidence so that it was proper in some way to rely upon him, unidentified, as the basis for his questioning. And yet Mr Resnicki can only be, at best, hearsay evidence. And when one looks at the transcript, fairly ambiguous hearsay evidence and uncertain hearsay evidence at that, there is no justification for preferring that piece of transcript to rely upon to question Mr Shorten, as opposed to the lengthy transcript of the interview with Mr Sass. As I say, there's no suggestion being put forward that there was reason to doubt the accuracy of what Mr Sass was saying. The evidence of Mr Resnicki that is relied upon at page 8 and 9, we have looked at. It's Mr Resnicki who says he assumes, but he's not sure, that it's Mr Sass who told him about something that had occurred before he had joined the project. And at line 20, in the course of those conversations, ideas would have been discussed about how to, how the union would represent itself on the site, whether there'd be non-working delegates, which are the hallmark of CFMEU agreements down in Victoria. So Mr Resnicki was saying that he believed that it was Mr Sass or Mr Connell, or perhaps Mr Sass only. So why in those circumstances, when Mr Sass, who was said to be the party to the discussion and any agreement that emerged, why would counsel assisting with respect in good faith rely upon that to question Mr Shorten? Nor is it an answer to say, well, Mr Shorten had counsel sitting in the hearing room with him. None of those counsel or solicitors had been advised that there was any such statement from Mr Sass, nor from Mr Resnicki, nor the basis for counsel assisting's questioning of Mr Shorten. Just before I go to the other matter of when what's described as the first complaint, in response to our concerns or raising of concerns about that process, we were most dismayed to be met by a fairly unsubtle threat for legal action for defamation. It's a pretty blunt instrument we would submit to respond to a complaint made in good faith about the process in a letter between solicitors. And insofar as Mr Stolzer says they were taken unawares this morning, Mr Zwire's letter of the 8th of October sets out chapter and verse exactly what the complaints were, and after describing some of those allegations or claims as defamatory, We were then told that we should be here to explain ourselves to the headmaster on Monday morning. So they could hardly have been taken by surprise by what's emerged this morning by way of our protest, as Commissioner, you quite properly describe it. And as I say, our concerns are not assuaged in any way, shape or form by the submissions of our learned friend. In terms of the decision to release the transcript of the interview and the transcript of the private hearing, and the suggestion that that was done out of a sense of fairness, we remind the Commission that that occurred after notification had been given on the Tuesday afternoon for cross-examination of the Tees John Holland witnesses. Now, what was suggested in subsequent correspondence was that that decision was made over the weekend, but the communication that that material was provided or was available came after the notification late on the Tuesday. And we ask, without necessarily expecting a helpful answer, if that was the decision reached over the weekend, albeit that Monday was a public holiday, why weren't we provided with it before the deadline for notification of cross-examination of witnesses on the 6th of October? That's our response, sir.
Yes.
Could I just deal with one small point, Commissioner, just picking up the last point that my friend made? The notification in respect of who my friend or his client wished to cross-examine was given to the Commission at 5:46 p.m. That appears from the document at tab 6. The ECB notification I'll just check that this is in evidence. The ECB notification is the last page behind tab 7. That went up, I'm told, at 6:13 p.m. Less than 30 minutes after the notification at tab 6 was given. And that coincidence of time, in my respectful submission, rebuts the proposition that the one triggered the other.
Yes. I think this is the time of day at which we have a short adjournment. So the hearing, let's say 5 to 12.
all stand. You may now be seated.
2 weeks have been set aside for a continuation of the hearings into some aspects of the Australian Workers' Union. This morning at 10 a.m, Mr. Clennon, on behalf of Mr. Shorten, applied for production of all Commission notes and recordings of meetings or discussions with Mr. Sass prior to Mr. Sass being called to give his evidence and cross-examined. I reject that application. Yes, Mr. Stroger.
I call Mr. Sass.
Do you solemnly, sincerely and truly declare and affirm that the evidence you shall give in this Royal Commission shall be the truth, the whole truth and nothing but the truth?
I do.
Please have a seat, Mr. Sass. Yes, Mr. Stroger.
Could you tell the Commission your full name?
Stephen Michael Sass.
You're a resident of New South Wales,
I am.
and your current occupation is Management Consultant in Industrial Relations and Work Health and Safety.
That's correct.
Now, you've prepared a witness statement dated 7 August 2015.
I did.
Is the content of that statement true and correct?
It is.
Commissioner, I'd ask that Mr. Sass's statement of that date be received into evidence.
Yes, if there's no objection, that'll be Sass, MFI 1.
Mr. Sass, can you just tell us something about your background? What did you do after you finished school?
I finished school in 1979 and completed an arts degree at the University of Melbourne. I then joined Shell Australia as an industrial relations officer, initially at head office and then at Clyde Refinery up here in Sydney. I had some years with them. I was then the National Employee Relations Manager for the paints business of ICI Australia. I then moved on to National Foods, then Goodman Fielder, and in 2000 I joined Transfield as the head of HR, IR and safety. Transfield at that stage was going through a significant restructure. The construction business that they had ended up being purchased by John Holland Group, which was a majority-owned company, majority-owned by Leighton Holdings at that time. That transaction completed in 2003, and I went on to basically head up the HR, IR safety organisational strategy function for John Holland Group.
And that was in early 03, I think you said?
That's correct.
And what was your actual title with John Holland?
The initial one was something like General Manager, HR, IR and Safety. It might have changed a little bit later on during my tenure.
And then just tell us briefly about your career after that.
After David Stewart succeeded Wal King as the Chief Executive Officer of Leighton Holdings, I went with David, which was 2010, to work for him as the Head of Organisational Strategy for Leighton Group. That probably lasted sort of 12, 14 months. And then since then, I've been doing my own consulting type business in the areas that you earlier described.
Now, I want to take you through your statement. So if you've got a copy of that with you,
I do.
can I ask you to look at the first page? And we'll start off there. The first heading is background, and you just set out some background in overview to the EastLink project. So construction commenced in March 05 and was completed June 2008. And why don't we focus on the paragraph with the heading Origins of the IR Strategy, just to begin with, because you set out the background by referring to some developments that preceded the EastLink project. And the first one that you make reference to is the Spencer Street station. Now, this is just by way of background to the IR strategy. Did you have personal involvement in the Spencer Street redevelopment?
No, the head contractor on Spencer Street was Leighton Contractors. Being a member of Leighton Group, we heard limited sort of internal gossip about what was going on the project. But the industrial relations aspects of it received very wide press coverage. And as part of planning for the EastLink industrial strategy, I actually spent half a day with the project director down there talking to him about the issues that he was dealing with.
Well, based on that involvement and the material that you read, what were the factors to your mind that led to it being late and over budget?
There were probably two classes of issues. One was operational in nature in terms of their ability to access what was in fact a live rail operation to do construction work, and I don't think that had been very well planned for. But the second and probably more relevant area was the industrial relations aspect, where they had a very high number of non-working delegates, which are a source of enormous inefficiency on construction projects.
Why is that?
These are people who are notionally employees of the company, but who are effectively full-time carrying out various duties on behalf of the union that they represent. They interfere in managerial decision-making, they create often bogus safety issues, and they are an enormous inefficiency in terms of physically getting work done and a distraction to site supervision.
Well, you deal with this really in subparagraph B under the heading Key Barriers to Productivity. You say Spencer Street Station was reputed to have had approximately 20.
Yes.
And you said that there was disruption. Is it also a cost to the project in respect of paying for the delegates?
Well, yes. If you take the total cost of employment in that industry at that time of being, say, $100,000 to $120,000 a year times 20 times the duration of the project, that's a reasonable number.
Well, let's just focus on that paragraph, Key Barriers to Productivity. This is all just by way of background to the strategy you set up. You've set out some matters in subparagraphs A through to E. So lockdown weekends, is the position that you wanted greater flexibility than what you've articulated in A?
Well, ideally, you would like the right to roster work 7 days a week, and provided that some or all of the workforce is prepared to work it, that aids productivity enormously.
Mm-hmm.
The lockdown weekend phenomenon is a situation where rostered days off are accrued, placed next to weekends, next to public holidays, so that you can get sort of periods of 4, 5, 6 days, depending on where you are in the calendar, where you can't work at all.
Right. And you wish to avoid that outcome in the Eastlink project?
Absolutely. It's a major constraint on productivity, and it's vitally important in constructing roads, because much of the work that needs to be done in terms of for everything really from preparing the base to laying the blacktop requires reasonable weather.
All right, well, speaking of weather, you deal with inclement weather in subparagraph C. Just explain the issue that you are articulating there.
So at that time, the construction unions, well, principally CFMEU projects, had a wide practice of abusing the inclement weather provisions in the applicable industrial instruments. So it might be raining somewhere on a project, in this case a project that's the better part of 40 kilometres long, and if it's raining in Mitcham, we stop work in Frankston, even though the weather patterns in Melbourne in particular are such that you can get very localised rain that doesn't spread very far. And if inclement weather is triggered, basically the whole workforce either goes into the shed for a period of time, or more usually in Victoria, goes home on full pay.
We'll come to the paragraph headed preparation, and you say you prepared a first draft of a strategy paper, but you, in any event, a strategy paper was prepared, and then you deal with the CFMEU at the bottom of page 2, but I won't take you through that in detail, because ultimately is this the short point really in respect to the CFMEU, that whatever the strategy was, it fell away somewhat?
My expectation was that the CFMEU would never agree to the conditions that we sought, principally in those areas that we just discussed as barriers to productivity. And I also had an expectation that had we been able to mobilise the project without those restrictions, the CFMEU would target it, and that can be quite a challenging issue to manage.
Right. All right, but the the short point is you say that you had some meetings and the like, but ultimately you really turned to the AWU for the purposes of developing an EBA.
Yes.
And you deal with that from the top of page 3. So let's start going through the paragraphs at the top of page 3. So the second leg of the strategy, that's after you'd taken some steps in respect to the CFMEU that you've articulated on page 2. The second leg was to meet with the AWU, Bill Shorten, and advise them of it was our intention to mobilise the project on AWAs unless the AWU is prepared to enter into a greenfield agreement. So when you say meet with the AWU, Bill Shorten, who actually attended these meetings?
The initial meetings were me and Mr. Shorten.
All right, and when were they?
At the end of 2004.
Can you be any more precise?
From memory, the discussions probably formally started around September, October.
When did Connect East win again? It was around about that time, wasn't it?
I think we got financial close probably in November.
So meetings are taking place in September, October?
Yeah.
Just between you and Mr. Shorten?
The initial discussions were just the two of us, yeah.
Where were those meetings?
I think we met in Melbourne, we'd met in Sydney, there'd been telephone conversations.
So there were a number of meetings?
Yeah.
And you were talking, well, you tell me, what were you talking about at the meetings? Can you remember the discussion?
The sort of the premise from the company side was pretty simple. It was really, if you don't give us the flexibilities that we want, we will mobilise the project on AWAs, which under the then labour relations regulatory framework were statutory agreements that locked out the unions completely. And our assumption had been that Mr. Shorten would prefer to have the AWU as party to a collective agreement than have a project of this magnitude mobilised on AWAs. And once that principle was agreed, with the corollary being that none of the restrictive practices that we've talked about would be part of the agreement, it was a pretty simple discussion.
Well, did you talk through the workplace flexibilities that you were looking for? So the matters that you've grouped under the heading Key Barriers to Productivity on pages 1 and 2?
Yes.
You talked those through in those early meetings?
Yes.
And was any in principle agreement reached about those matters?
The in principle agreement that was reached at the end of our initial discussions was that we would have an AW-only agreement for the project, that none of those restrictive practices would form a part of it, and that we would be paying what would be recognised without argument as being the highest rates and conditions in the industry at the time.
Well, and what about the matters that are set out in the second paragraph under the heading the strategy AWU, suggested by entering into such an agreement? Was that also a feature of the discussion?
Yes, it was. I took the view that if the AWU was the sole party to a project of this magnitude and importance, it would go a long way to reinstating the AWU as the principal union in civil construction, which was a position that had been systematically eroded away over the 15 to 20 years before that, as the CFMEU started moving out of commercial building and increasingly into civil projects, and bringing with it these work practices that are generally characteristic of commercial building rather than civil.
And you go on to say central to the company's position was that the agreement was to be with the AW only. That's part of it, in a sense, is that what you were just discussing is that you wanted this to be an AWU arrangement.
Yes, because my assessment was that the CFMEU under no circumstances would agree to the sorts of flexibilities that we wanted.
Right. And then you're saying rates of pay and other employment conditions would be higher than on any other project then underway. You've already touched on that to some extent.
Yes, within reason, the dollar rates that are in the wages schedule of the agreement are probably not as important as your ability to mobilise labour when and how you want it without restriction. So if we got the flexibilities that we wanted, then the unit hourly rate was of secondary importance.
Now, you then say under the heading AW negotiation, a high-level in-principle agreement was reached between Shorten and me in late 2004. How long did these early negotiations go on for?
Not more than 4 to 6 weeks at the most.
And it was still just you and Mr Shorten at that stage?
Yeah, predominantly, yeah.
Well, when you say predominantly, were others involved?
At the end of the process, we sort of started handing over to, so Caesar Mellon was taking over certainly a project of this importance directly as Assistant Secretary, I think he was at the time, and we had appointed Julian Resniewski to be the site or the project HR IR Safety General Manager, and the plan was that as soon as possible they would take carriage of the matter from there. So there would have been one, possibly two discussions instead of handing stuff over.
Again in late 2004?
Yes.
And were those discussions, well, you tell me, who were those discussions attended by?
There would have been me, Mr Shorten, Mr Mellon, Mr Resniewski, Mike Connell would have been at one or two.
And where were they, Melbourne or Sydney?
All in Melbourne from memory, yep.
Now you say, you go on to say that, when I say go on, I'm now looking at the second paragraph under the heading, the AW negotiation. You go on to say there was some limited discussion in relation to how the AW would ensure that the workforce on Eastlink would become members of the AWU. These discussions included the possibility that the project might directly fund the costs of an organiser, salary plus car equating to approximately $100,000 per annum, but this was not finalised. And the idea did not form part of the in-principle agreement. Now, who was present at the discussion about the organisers?
Me and Mr Shorten.
And the other gentlemen that you've mentioned this morning, Mr Mellon, Mr Resniewski and Mr Connell, were they present at any stage?
It may have come up in a handover meeting at some stage.
Right, but the discussions to which you make reference under the heading AW negotiation about the organiser, they were between you and Mr Shorten?
Yes.
And can you, doing the best you can, what was said about that topic?
So from the union's perspective, their income is essentially the union dues that members pay. So it's an important business imperative, if you like, for unions to attract and retain financial members. In the dim, dark days, employers would run closed shops, and it would be you would have no option as an employee but to become a financial member of the union. That had all fallen away. It would have been unlawful for us to run a closed shop, and as a company we wouldn't have done it anyway. So the unions look for opportunities to capture that workforce as members. So they might want to have the right to present at an induction, for example, to sell their wares to prospective members who are employees of the company. So one of the discussions that came out of this negotiation I had with Mr Shorten was that if the AWU had a dedicated organiser on the project, then that would enhance the union's ability to maximise the proportion of employees who are members of the union. Now, in normal circumstances...
Pausing there, did someone actually say that?
Well, his suggestion was that an organiser would be basically appointed full-time to the project and funded by us.
Whose suggestion?
Mr Shorten's.
So an organiser would be appointed full-time and paid for by you?
Yes.
And where were you when that suggestion was made?
I couldn't give you the specific discussion, location and time, but it was part of the these principles that we were discussing that would underpin the agreement.
And what did you say?
Well, normally I would have not countenanced the suggestion for a moment, but in a situation where we had an AW-only project that had the duration and physical footprint that Eastlink had the CFMEU decided to make its presence felt on the job, that could have been an enormous disruption. And you can look at disputes like the Westgate dispute back in 2010 in Melbourne to get a feeling for what happens when the CFMEU is in full battle formation taking on a project. The legal remedies are generally just not sufficient to manage it. So I thought to myself, if I have an AWU site, which I was expecting to get at that time, then maybe having a dedicated AWU organiser who was on the site full-time might be not a bad preemptive defence to manage some of this CFMEU risk. And effectively, I thought about it at the time as having a site employee relations manager who was wearing a different coloured shirt to everybody else.
When you say wearing a different shirt, you mean an AWU shirt,
Yes,
but paid for by you.
yes.
You said, I'll come back to this conversation in a moment, but you said at one point in your answer, normally I would not countenance that for a moment. Did I hear you correctly to say that?
Yeah.
But why do you say that?
Well, the implication of having an organiser on a project full time is that, from the company's perspective, is that as an employer you can't manage your workforce effectively, and that's not a good look. I think for most major corporates, they would prefer to think that their systems, workplace cultures, supervisors can manage employee grievances and issues on their own without the need of having an external third party intervening.
All right then. Now, coming back to the discussion, do you say you had only one discussion about this, or more than one?
1 to 2, no more than 3.
And can I just bring your mind back to this conversation? I think you said, and please correct me if I'm wrong, don't just agree with me, but my understanding of your evidence was that Mr. Shorten made a suggestion to the effect that there be an organiser full-time paid for by you, that is to say Holland, or at least the joint venture. Now, and you went through what went through your mind at that time, but what did you actually say in response?
I was deliberately very non-committal about that proposal for a couple of reasons. One, I think I explained earlier, it's not something that I particularly like the look of, and two, I had not taken it back up the line for any kind of authority in terms of the overall negotiation strategy. And while I would consider a financial commitment of that magnitude to be well within my authority to make, it was a significant departure from the approved IR strategy that had gone all the way up to the Latent Holdings executive for approval.
Well, what did you actually say to him? Can you remember? You said you were non-committal, but what did you say?
So I might have ummed and ahed and kept it open and not said no, and basically, my primary objective was to get the Greenfield agreement signed off. Once I had that, I didn't need too much more support from the union.
So you didn't say no, you ummed and ahed.
Yeah.
And you can't remember with any more precision what you actually said.
I can't give you the precise words, but my position at the time was that it was something that we would be open to discussing, but I did not commit to it formally.
Now, when the suggestion's been made, an organiser full-time, paid for by the joint venture, was there discussion about how much the organiser would be paid in these early meetings?
I'm reasonably certain that there was.
Well, what was the nature of that discussion? Was a figure actually mentioned?
My recollection is that a figure was mentioned, and it was $75,000 a year plus car.
All right. And where does the $75,000 come from?
That's my recollection of what the number that was being discussed was. So when someone asks you to pay for something, you normally want to get a pretty precise handle on what the figure is.
Well, did you, when he said to you, an organiser full-time and paid for by me, did you ask a question as to how much the payment would be?
I might have made an assertion, so that would be, $75K plus car.
And what would be the total?
$100K per annum.
See, you've been sitting in the hearing room today, I take it?
Yes, I have.
And you've heard some discussion about a interview that you gave with the Commission. I just want to take you to a passage in that interview, and I'm going to take you to some other documents as well. Now, can I give Mr. Sass a copy? I'll just track you down a copy, Mr. Sass.
Thank you.
Now go to page 12. And if you need me to put this into, or if you need to put it into context. Sorry? Just so you're not jumping in the middle of an interview, Mr. Sass, perhaps if I'll take you back to 11, 14. This is just to give you some context. You say, so the one discussion I'd had was a loose discussion with Mr. Shorten, and then keep going down that page. And then come to the top of the next page, page 12. Sorry, tell me if you need time.
Yeah, no, all good.
Yep. And you're asked, did he have a named organiser in mind? And then you're asked at 15, did he say that 100 grand would be the salary plus car? And you responded, no, I'm just putting two and two together in terms of numbers. Did he talk about a specific number? No, he did not. Okay.
Yeah, my recollection is that a number was discussed. I just can't remember exactly whether I might have come up with it, whether he came up with it, whether I suggested it to him. But that number, that 100k per annum, 300k for the project, was part of the discussion.
The early discussion with
Yes.
Mr. Shorten.
Yeah.
All right. Well, I'll take you also to. I'll see if you can be provided with your transcript of the private hearing. You touch on this as well there. So you recollect you had a private hearing at the Commission on the 7th of August,
Yes, I do.
and perhaps pick this up from page 26, line 34. And you say there, you're really talking about the same matter again. A request was made to us or to me by Mr. Shorten that we should fund a dedicated organiser for the project that would have primarily the responsible making sure that workers were signed up, etc. And then come over to the top of the next page, or read through the rest of 26 if you need to put it in context, and come to the top of the next page. You say there, were these matters that were actually discussed by Bill Shorten and yourself? Yes, they were. Was there any discussion the salary the organiser might receive? Yes. Number that was worked with was the cost of a union official plus car is 100 grand a year over the life of the project, the 3-year project. Came up in the context of membership. That was the start of the discussion. So is this the position that this was all discussed in that one, or I think you said possibly two or more conversations that you had with Mr. Shorten in these early days?
Yes.
Well, why did you say in your interview, if I just take you back to that, on page 12, you do say there, well, let's look at it again. Line 21, I'm just putting just put it in context again, I'm just putting two and two together in terms of the numbers. Then line 21, did he talk about a specific number? No, he did not. Okay, no. He just said, look, the best way to buttress the project is to have a dedicated AW organiser. Yeah. Aren't you really suggesting there that he didn't talk about a specific number?
I think we were talking orders of magnitude here, not precise salary definitions and numbers. So My recollection is that I left the first discussion with a number in my head of 100,000 a year as what it would cost me if I agreed to this.
Right.
And that would have had some indication from him as to what he was paying his organisers, because that's not information I would otherwise be privy to.
Right. You say, and today you said that you thought what was said was 75. Elsewhere you've said 80, haven't you? Or you're not sure?
We're talking an order of magnitude. I was looking at it from the perspective that what was it going to cost me if I agreed to this?
Yes.
And I was working off 100,000 a year.
And to your mind, that included salary plus car?
Plus superannuation, yeah.
All right, so you had those discussions. In your statement, began this by taking you through your statement. You say this was not finalised. The idea did not. I'm sorry, that's on page 3, second paragraph, about the middle of that paragraph. This was not finalised, and the idea did not form part of the in-principle agreement. Was the in-principle agreement written down?
I'm fairly certain that there was a high-level heads of agreement document floating around. It may have been in the form of an email, but it was certainly documented, particularly around our preliminary views on what the wage levels would be, which is obviously a headline issue for him. But I've been unable to secure any of that kind of documentation.
Well, you touch on this a little bit in the box at the top of your first page. You say, I require access to John Holland Company files and email calendar records. Did you keep notes of these meetings that you were having with Mr. Shorten?
Yes, I did. I kept extensive notes. And I also, because this whole strategy contemplated very, very significant industrial relations risk in 2 levels. So although we've discounted the CFMEU part of the strategy, we had expected that by provoking them into taking action, they might take industrial action against all the Leighton Group companies in Victoria. So there was a lot of attention from the company to watch and understand what was going on with the negotiations. And secondly, if we'd been unable to secure the flexibilities that we needed for the project, the costs, the labour costs and labour productivities on the project would have been unsustainably high. So there was a lot of senior management interest. There were a lot of email traffic flying to and from me to the people that I dealt with in the joint venture, who were the key decision makers. There were extensive records kept.
Right. Well, let's perhaps take that in steps just to explore it a bit further. You said first of all that you took extensive notes. What were these in notebooks that you had?
Yes, in notebooks that look exactly the same as these.
So you're holding up a red Collins ledger book?
Yep, with numbered pages.
With numbered pages. And, well, the short point is I can indicate to you, Commissioner, that the Commission's made extensive efforts to try and track down these notebooks, but at this point they're not able to be found. Well, where did you leave them? Where did you see these last, Mr. Sass?
When I left John Holland, I handed both my notebooks and my paper diaries to my PA with very clear instructions to put them somewhere where they could be found again, and made a comment, someone somewhere will want this.
All right. And then I may tend to something about this in due course, Commissioner, but then there were email traffic between yourself and your superiors at either the joint venture or at Holland anyway?
Extensive, and there would also have been file notes that would have been converted from handwritten notes in my red notebook into a MS Word document and saved on the IT system, keeping track of what was going on here. So there was a proper file note and a proper trail of evidence and a proper chronology, so that if the wheels fell off and we ended up in some piece of litigation, all of the information could be gotten at very quickly and efficiently.
All right. Anyway, you last saw those notebooks when you left Holland.
Yes.
Now, round about the end of 2004, Julian Resnevecki came in, and perhaps I'll take you to another passage in your private hearing transcript. page 33. So I start asking you about the handover to Mr. Resnevecki at about 33, on page 33. And I asked whether you briefed him, just have a read of this
Hang
yourself.
on, it's not on my page 33. Am I on the right one?
This is the private hearing on the 7th
Oh, sorry, the
of
private hearing.
August.
Yep.
Page 33, line 33.
Yes, got it.
And you say, Julian, I said, did you brief him on those discussions that you'd had? So Julian, I go back, just read this yourself. And then going over to the next page.
Yep.
Now, does that accurately reflect your memory of your briefing of Mr. Resnevecki?
It does.
Did you hand over to him any documentary material, notebooks or emails or the like?
I certainly gave him a copy of the strategy document, and he would have been on the receiving end of emails almost certainly before he started formally with the project, because I knew I had him coming for, I think he had to give 4 to 6 weeks, maybe 8 weeks notice out of his current employer. We'd agreed he was coming across, and I was keeping him in the loop with the discussions that they were going. I was also catching up with him face to face whenever the opportunity presented itself to keep him in the loop of what was going on.
Right. Now, at that stage, I mean, this is in a sense a legal question rather than a factual question, but to your mind, had an agreement been reached, a binding agreement on the topic of the organiser?
Well, I guess I'm going to give you a legal response. Nothing is legal in this space until it's been through the then AIRC approval processes. So you can have a heads of agreement, but that's in an industrial law sense that has no binding effect at all.
Sorry, I wasn't talking about the EA. I was talking about the arrangement pursuant to which the joint venture would fund a organiser.
No.
So that was something. Just tell me about this. This is just your mind, but just for what it's worth, tell us, to your mind, what status had that arrangement reached at this point? That is to say, you'd had the discussions and you're about to hand over to Mr. Resnevecki.
So I'm pretty certain before Julian formally joined the project, I'd had a phone call from Mr. Shorten very soon after what I felt was finalising the sort of heads of agreement, the key principles that we were going to go forward under and finalise the Greenfield Agreement. And that in that phone call, he said he was bringing the CFMEU into the agreement, into the deal. And that was a fait accompli and we could do nothing about it. So from that point, any logic about funding an organiser disappears completely.
From your point of view?
Yes, it's...
Right. Well, you now you touch on this with... when did you receive this telephone call, approximately? Or if it's easier, just describe it in terms of the stages in the process rather than dates or anything like that.
It was within a couple of days of, in my mind, I had an in-principle agreement with him as to what the terms of the Greenfield Agreement would look like. And again, the email trail at the time and the notes would demonstrate exactly what was going to be in it and when that was reached. And within a couple of days after, in my mind, I had an agreement, he told me that he was bringing the CFMEU into the deal.
Is this the matter that you're adverting to in the second paragraph of your statement on page 3, beginning with the word secondly, about halfway through that?
Yes?
So you found out about this by way of a telephone conversation, did you?
Yes.
And do you recollect, as best you can, why the reasons why the CFMEU had now become involved?
Well, he didn't give me any reason. I drew my own conclusions as to why he might have done what he did.
But that was something that took you by surprise, was it?
It was a complete departure from the whole tenor of the negotiation to date.
And in trying to understand the sequence of events, you're having discussions September, October, yourself and Mr. Shorten, and you've talked through the flexibilities that you wanted in the EA.
Yep.
And you talked through the proposal pursuant to which the joint venture would fund an organiser. And then, is that right?
Yes.
And then Mr. Resnevecki's, you're looking at bringing him in so you can get back to Sydney and do whatever it is that you wanted to do. And it was at some point around about that time that the telephone call came about the CFMEU.
That's correct.
And that took you by surprise, did it?
It did.
And you felt that was a retreat from what had been previously on the table.
A very fundamental retreat.
And did you say that to Mr. Shorten?
I think I put it more bluntly than that.
Or what did you say?
I think I would have used language that was strong and around, you've just ratted on the deal.
And what did he say?
He made a statement to the effect that it was because of issues that I remember very clearly that I would not understand.
All right. And you've set out some, as I say, some matters about that in the second paragraph on page 3. Now, did you have, after that time, did you have further discussions with Mr. Shorten, or for that matter, Mr. Mellom, about either the EA or the proposal about the organiser that we've discussed?
Very little, if any. So at that point, Julian picked up the situation with all of its complexity and uncertainty, and because the CFMEU were now in the mix, the only sort of feasible step forward was to go through an extensive conciliation process in what was then the AIRC, which Julian ran, and I think went for the better part of 3 months.
So that's from roughly January through to March 2005?
That's probably about right.
And was that in relation for an EA for the AW and also for the CFMEU?
So mirror EAs were made with both unions.
Right. Now, I'm going to ask you some questions about some other people's evidence around about, or in respect to these topics, but I just want to, as it were, get the full picture first. So if we can just work through some further matters. In your statement on page 4, well, you touch on again the discussion about the organiser in the first paragraph. I won't take you through that again. But if you come down to the paragraph headed Payments to the AWU-3, you say, I was not aware of the magnitude of the total payments made by the JV to the AWU until the TURC process made them public. It appears that the total payments approximate the $300,000 initially discussed between Shorten and me, and that the relevant documentation was deliberately falsified. If I can take you through that in two halves. When you say the $300,000 initially discussed between Shorten and me, was $300,000 as put on the table as a number in these discussions?
I recall that it was, because in my own mind, all the way along, that's what I thought of the commitment would be if I committed to it.
Well, what was said about that number?
That would be the cost of funding an official for the duration of the project.
On the basis of what? It's a 3-year project.
3-year project, and back to the $100,000 a year discussion we were having earlier.
But I'm just trying to understand. Did you told us about discussion earlier where a figure for salary was mentioned, and with the car it arrived at $100,000. Was there? What was actually said about the total amount that might be payable? Do you remember, or are you really just drawing an inference about what you think might have been said?
Well, I think it's stronger than an inference. I mean, $100,000 a year times 3 years gives you the number.
Well, what I'm really asking is, was that number actually discussed, or do you not have a memory one way or the other, or what?
I really couldn't give you a very precise answer to that, because I think part of it, in my mind, I think of it as $300,000 as a cost line I've got to think about in terms of the project. Other people might not think about it in that way.
Right. All right. Well, then you say the relevant documentation was deliberately falsified. You're talking about invoices, are you?
Yes.
But were you involved yourself in approving invoices or paying invoices?
Not for this project, no.
So the first time you saw these invoices was in the when they emerged in evidence in this commission?
Yes, and in the interview process.
Oh, yes. Now, can I take you through some of those now? If you have a look at a volume that's been marked short in MFI 9, I won't take you through every one, but I just want to take you to a few of them. If you go to page 168, capital A,
Yes.
and so drawing from your last answer, you saw this for the first time, did you, during the commission process?
Yes.
But did John Holland advertise in the Australian Worker magazine from time to time?
The Victorian branch of the business might have. I can't recall. I hope not.
Well, there were certainly some advertisements in the Australian Worker magazine. You accept that?
For John Holland.
Either John Holland or the joint venture.
Well, there's a distinction there. I mean, John Holland, in its own right, if there'd been an agreement to put a sponsorship arrangement into the Victorian branch of the AWU's newsletter, it would have been done by the local branch. I wouldn't have approved something like that.
Well, to your mind, what would be the benefit to either John Holland or the joint venture in placing an advertisement of that kind?
Very little tangible benefit. You might agree to something like that if there was a particularly close relationship with a particular organiser that you wanted to foster, but that's a pretty significant sum of money for no tangible return.
Can I take you through to page 170? I'm proceeding on the assumption at the moment that you hadn't seen these invoices at the time. I think you've given some evidence to that effect before, but if you see one that you did see at the time, just let me know.
I will.
So this is tax invoice 010410, Population Forum. And there's some information about it on 171. Well, why would an employer be interested in having employees go to a population forum?
Well, no sensible employer would.
Do you have any knowledge as to whether it looks like 20 persons went to that forum, you yourself?
I don't.
It appears to have taken the whole day from 8 a.m. to 3:30 p.m. Do you think that would be a useful use of employees' time on the joint venture?
Precisely not. It's hugely expensive, and even assuming that if 20 people went, the opportunity cost of them not having to do their day job on what is a project that is almost its entire existence is on a critical path is not something that we would want to contemplate for a second.
Can you have a look at 171? Well, in fact, I won't take you through all the different advertising invoices or the balls and the like. I'll take you directly to 186. Just have a read of that invoice. So it's an invoice for research work done on backstrain. Do you have any recollection of whether the joint venture commissioned any research work done on backstrain in the civil construction industry?
If they did, it was without my knowledge.
Would it typically, if it did that, would it typically commission that work from the AWU?
That would be unorthodox.
Why do you say that?
Well, the AWU is not really equipped to do research into ergonomics and work health and safety issues.
Well, who would you get to do it if you wanted someone to do it?
I would go to, if I was in Victoria, I'd probably go to RMIT University. They have a very capable set of academics who work in the WHS space.
The joint venture, this is an invoice to the joint venture, not to either of the corporate parents, if I can put it that way. Does that give you any cause to have a concern about this invoice, in the sense that the joint venture is dealing with a 3-year project?
Well, only in the sense that by the time, the commercial implications of backstrain in civil construction are, one, around occupational health and safety performance, and two, implications for, say, workers' compensation claims costs. Now, by the time the latter come to effect, the project's finished and gone. So projects don't typically get involved in research projects of this nature. This is the sorts of things that parent companies do that are ongoing businesses with an exposure to this kind of risk. So it's very unusual that a project would get itself involved in something like this.
In the, well, the project really is there to try and build this roadway as quickly as possible, isn't it?
Exactly right.
In the private hearing, you said something to the effect it stretches the bounds of credulity to think this is a genuine invoice.
Yes.
Do you adhere to that?
I do.
And what are your reasons for that observation? The ones you've articulated, or are there more?
Well, the reasons I've just given you, but also the fact that the invoices collectively add up to that 300K figure, plus or minus 1 or 2%.
Does it look like a bogus invoice to you?
I fear so.
What would you need to see, you yourself, to authorise payment of an invoice like this?
Well, a normal procurement process for something like this might have a scope of work. It might have a tender from the supplier or one of more suppliers who you're looking at for doing it. Something like this is very nebulous, so a fair amount of work goes into defining what's the deliverable that we're getting at the end.
So scope of work, tender. Well, the deliverable you're getting at the end, you mean some sort of report or the like?
Set of report, set of recommendations, it's something so that when the company goes into the contract with the consultant or the provider of the services, it's got some sense of what it's going to get for its money.
Well, let's just talk through that in a bit more detail. Some need would need to be demonstrated for the research project, wouldn't it?
Yes.
And so when you say procurement process for something like this, or a tender, among other things, a need would need to be demonstrated. And then I presume there'd be discussion at management level.
Something like this, if we take this example, your work health and safety function might be analysing your claims history and saying, we've got a lot of incidences coming through in workers' comp claims that suggest that we're getting backstrain issues, and it's going to have a commercial impact on our workers' compensation premiums. So let's look at what we can do differently to reduce that work health and safety risk on the job. And then that would get converted into some kind of written recommendation, and it would usually get signed off by someone that, yes, this looks like a good idea and we'll go ahead and do it.
Right. And then once the results came through, would they be disseminated in some way?
You would hope that the result would give you a useful recommendation to make change, so we would have to, yes.
And to your recollection, were either that process of procurement or that process of dissemination of results, was that undertaken in the context of this joint venture,
Well,
that you can recollect?
I knew nothing about it and know nothing about it, so no.
Have a look at page 196. Now you're talking there about that invoice relates to purchase of tickets for a IR regulation seminar. Now, is a seminar of that kind something that Holland or the joint venture you think would be interested in attending?
No.
Why do you say that?
Well, if we want some information about whatever IR regulations are being referred to, we would get them from our industrial solicitors.
That would be the typical practice.
Yes.
Can you go to page 199? This is an exchange of emails of 12 September 2006 between Mr Resniewicki and Mr Mellon. Did you see these emails at any stage prior to the commission process?
No.
Did Mr Resniewicki discuss either these emails or this arrangement more generally with you?
No.
Did anyone else?
No.
Just to be clear on that, after around about the end of 2004, Mr Resniewicki took over, did you have any more discussions with him about the possibility of funding an organiser? Back in, this would now be from the beginning of 2005 on.
No, because the entire logic for it had fallen away completely.
And what about anyone else from the AWU?
It may have come up in a handover meeting that maybe Caesar Mellon might have been at, but that's it.
But you yourself, what, you were now based back in Sydney?
Well, I've been based in Sydney all along, but the point was once you get someone of Julian's calibre into a job like this, he doesn't need supervision from me.
Right, but is this the position that and he started around about December 2004, is that right?
That's right.
And from that time, you didn't have a hands-on or day-to-day involvement in the project?
Absolutely not.
Can I ask you to have a look at 207? This is another one for advertising in the Australian Worker magazine. This is for $33,000. Would you describe that as typical or usual?
Sorry, typical?
Or usual?
No.
And I realise you didn't approve or authorise the tax invoice, but what comment would you make about that?
Well, it's an awful lot of advertising.
Well, you mean in this particular magazine? I mean, I take it there are other media outlets where you might spend that sort of money.
It'd be challenging to spend that kind of money unless you took out a full-page ad in the Fin.
Well, would you have any concerns about this invoice?
Yes, I would.
And what would those concerns be?
The need for it in the first place and the value associated with it.
Well, when you say the need for it in the first place, is that touching on the evidence you gave earlier about the benefit or commercial benefit or otherwise that might be obtained?
Yes.
You said when you gave your evidence earlier something like if you were trying to foster or you had some relationship you were trying to foster, you might put in an advertisement of that kind?
Yes.
But I take it you say not for this amount. Is that what you say?
No. In my mind, if someone asks you to put your company logo on the back of their journal or in what we used to call award books, I'd be thinking $450, $500.
Can you go back to 206? This is an invoice for sponsorship of OH&S conference. Were there circumstances in which the joint venture or John Holland would sponsor a conference?
John Holland would not. Again, I'm not quite sure what this is. I had a practice when I was responsible for the work health and safety function in John Holland of bringing together every year all of my health and safety reps from across the country for a couple of days to talk to them directly about their role, what we were doing, train them, educate them. It may have been something like that, but that's an awful lot of HSRs for one project, if that's indeed what it is. If it's a conference that the union was running and it put the Tees John Holland branding on it, it seems to me a limited commercial return to the company.
Were you able to assess what sort of commercial return there might be to the company from a sponsorship signing of that kind?
Somewhere close to zero.
Have a look at page 215, capital A. Now, this is a tax invoice for $100,000, but it was, as you can see from 215 capital B, it was broken up into, in substance, 3 instalments. But are you... Well, the instalments start on pages 217 and 218, 2 lots of $37,000. If you'd received an invoice for something, either the one on 215 capital A or the ones on 217 and 218, what sort of information would you need in order to make a payment on an invoice like that?
So the invoice should relate to a purchase order or to a contract or to some other document that creates the commercial relationship between the party invoicing and the party paying the invoice. Mm-hmm. There are very, very rare occasions where you might specifically request an invoice that's not specific or clear about what it's for, in which case most companies and most audit functions require a 2-up sign-off process to make sure that everything's above board.
Right. And did, as far as you know, did the joint venture have some sort of process of that kind in place at the time?
So in terms of how it procured services, yeah, construction companies have this ingrained in their DNA. They're very good about how they put the documentation around purchasing goods and services.
Just reading the invoice, are you able to form any view as to what sort of services might have been provided?
Well, no.
Can I ask you to have a look at a volume which has gone into evidence called and identified as Ralph MFI1.
That went into evidence at a private hearing, I think.
Oh, I'm sorry. Yes, well, in that case, if I could ask that the volume which has been marked Ralph MFI1 be received into evidence at this
It will be
hearing.
received into evidence and known, additionally, perhaps as SAS MFI2.
Yes. Could you have a look at page 23 of that folder? Now, these are some handwritten notes or diary notes prepared by Mr. Resnevecki. It's a meeting of 10 December 2004, and it looks like an internal meeting for representatives of the joint venture. I take it the SMS is yourself.
That's correct.
DJ is likely to be Don Johnson.
That's correct.
MC Mike Connell.
Correct.
CH Chris Herbert.
Correct.
This is a meeting that took place on or about that day. Do you have, sitting here today, any memory of the meeting?
I could remember having, that we would probably have had a meeting of this type. I can't tell you with any level of certainty what I was doing on the 10th of December in 2004.
Good. But reading the entries, does that jog your memory as to discussions you were having at about that time?
You can tell very clearly what the issues were that we were talking about.
All right, let's work through them. Industry demarc, what's that issue?
So by this stage, we're obviously now dealing with the fact that the CFMEU have come to join the party.
And you join that, you draw that conclusion in part from the fact it's talking about industry demarcation, but also is it the name that appears before the word wed?
Yes, but definitely you wouldn't, if you didn't have two unions, you wouldn't have a demarcation problem.
Right. And then, all right, so you're now dealing with that issue. So the telephone call that we've talked about earlier must have occurred prior to 10 December 2004.
Yes, definitely.
Anyway. And then road headers only?
So that would have only, whatever that refers to, would have only referred to the tunnelling component of the project. And I thought, I'd be surprised if road headers were used in conditions like that, but that's Julian's note, so you'll have to ask him that one.
And calendar applies? Do you remember discussion about that?
The calendar is the colloquial term that's used in the industry to refer to these restrictions on when you can and can't work with lockdown weekends and the like. So saying calendar applies means that the industry-wide calendar that puts in place when those lockdown weekends occur would be applying to that project.
And then 2 conveners employed by MFP?
Yep, so a convener is if you like, is a term that is not so much used these days, but certainly in the 60s and 70s, it was a very common position, which is like a senior shop steward, so an employee of the company, who has sort of a site-wide or a project-wide role. So they're effectively not working delegates.
Well, that explains what a convener is, but are you able to put the discussion into any broader context? What's actually being talked about there?
So what's being discussed with that kind of comment being made is, you know, whether or not we, the company, would agree to put effectively 2 non-working delegates onto the project.
But senior ones who would have a responsibility across the entire project?
Yeah.
Employed by MFP as the Mitcham-Frankston project.
Correct.
And then subbies pattern EBA.
So what that point would have referred to is that how we would look to have some kind of commonality between the flexibilities that the joint venture itself was looking for in respect of its directly hired workforce versus what would happen with works that were carried out by subcontractors.
And then MOU, what MOU are we talking about?
Well, there wasn't one, but where he says e.g. CW Games, there was a MOU signed at the behest of the Victorian State Government for, I think, the construction of a Commonwealth Games village with the intent of trying to avoid some of the typical Victorian construction disruption happening on that project.
I know the time, Commissioner.
Yes. We'll resume at 2 p.m.
Mr. Sass, I was asking you some questions about page 23 of the folder that's now been marked SAS MFI2. If you just keep that with you, I just want to ask you some questions about some evidence that Mr. Resnevecki's given, and then I'll come back to that page in a minute. Now, I just want to put this to you for your comment. This is evidence that Mr. Resnevecki's given elsewhere. And there's two versions of this. So there's one version I'm going to ask you, which is, just so you know, comes from a private hearing, and the other that comes from slightly different, that comes from a statement that we've received very recently. So can I just work through the first set of evidence? Now, he says that before he joined the project, there'd been some high-level discussions between the AWU and representatives of the joint venture parents. I take it you'd agree with that proposition?
I would.
And then he says that the parties to those discussions were trying to set up a framework under which the industrial relations arrangements for the projects would be put in place.
Yes.
And his evidence was that during the course of those conversations, ideas would have been discussed as to how the union would represent itself on the site, including whether there would be non-working delegates.
Yes.
And he said there was discussion around putting a more creative solution in place.
Yes.
He says his understanding was that there was an arrangement agreed that the joint venture would provide resources to the AWU to assist them to provide organisers to the project.
It probably depends at what stage of the discussions that we're at, because of what we were saying before we adjourned is that as the CFEU comes in as a party to the arrangement, the logic of supporting one union over the other disappears.
Okay. So you say that might reflect the position prior to the CFMEU coming in, but not subsequently. Is that what you're saying?
In my mind, yes.
Right. He says that while there was some, in general terms, he believed an agreement had been reached before December 2004.
The high-level agreement?
No, he's talking about an arrangement pursuant to which resources would be provided to the AWU to assist them to provide organisers to the project.
Well, that's probably referring to the agreement about us funding an organiser.
Right. Before December 2004?
September?
December.
Oh, December. That's about right.
And he says the parties were certainly Mr. Shorten, probably Mr. Mellom and Mr. Sass. Well, why don't we take that in steps? To the extent he says the parties were Mr. Shorten and Mr. Sass, do you
Yes.
agree with that? He says probably Mr. Mellom. What do you say about that?
Mr. Mellom's involvement, I can't remember precisely when it started and whether it was consistent, from one meeting, every subsequent meeting he was at, but yeah, things were certainly being handed over to him at the same time I was handing over to Julian.
Right. And he said he wasn't sure as to whether Mr. Connell was involved in reaching that arrangement or agreement.
Mr. Connell was around for some of the discussions, would have been on the rear end of email sort of updates. I had primary carriage of it.
And he says, as he understood it, the arrangement was to provide financial resources, that is to say financial resources, and a figure was mentioned of nominally $100,000 a year plus GST. Do you agree with that?
Yes.
Now, there's we've received just trying to remember, I don't think it's been signed, has it? We've received an unsigned statement from Mr. Resnevecki, which may have put a different slant on things, and it addresses some of those documents I've taken you to. So I just want to walk you through that and see what you say. So we expect that this evidence may be given tomorrow, assuming this statement is signed. So he says there was an understanding regarding the provision of support for the project, that is to say, in the discussions, by December 2004, he says there was an understanding with the AWU regarding the provision of support for the project.
I'd agree with that.
But then he says the dollar value of that support was not settled at that time, that is December 2004.
Okay, and this goes back to this question of, was it a discussion about an organiser full-time for 3 years or the $300,000, which to me are largely interchangeable concepts?
Right. Well, just to be clear, what he is saying as we read his statement, and of course we'll have to address this with him tomorrow, is that that topic, namely the quantum of the financial support, was the subject of discussions within the JV and between the JV and the AWU during the period from early December 2004 to March 2005. Are you able to comment on that?
So it seems to me that the logic of funding an organiser fell away completely when the CFMEU came in. I couldn't understand why there's no reason to do it, but it seems to have kept itself alive as an idea through that 3-month period of negotiations that I was not involved with.
Right. But you weren't personally involved in these discussions, well, certainly after January 05 up to March 2005.
I handed it over pretty much completely.
Right. See, I want to take you back to that page 23. Yep. So that's page 23 of SAS MFI2. So it's a diary note by Mr. Resnevecki of what seems to have been an internal discussion. And I took you through the main topics. But if you have a look at 2 conveners employed by the MFP, the Mitcham to Frankston project, his recollection is that the topic there being discussed was the same topic, that is, or at least it related to the same topic, namely, he says, a claim or request that the JV employ 2 conveners on the project. So it's about, do you have any, are you able to shed any light on that now as you sit here today, as to whether that was the topic being discussed or whether that was just a matter that came up at that meeting?
Oh no, I think if it's in Julian's notes, then I'm sure we would have discussed it.
Oh, quite. But does that relate to, in your mind, the arrangement that about funding an organiser, or is this dealing with a different topic?
No, this is exactly the same issue. It's how does the union establish a presence on the site, right, to look after its interests, which are first and foremost increasing or maintaining its membership.
But we're here now talking about 2 conveners and talking about them being employed by the MFP, which is rather different from what you had discussed with Mr. Shorten, as I understood it from your evidence.
But the principle and the objectives are the same.
Quite, but this seems to be a different proposition from the one that you discussed with Mr. Shorten, isn't it?
Yes, it is.
Because we're talking about 2 conveners and we're talking about them, step 1 is 2 conveners if that's identical with an organiser, not 1, but secondly, and perhaps more importantly, employed by the MFP.
Yeah.
That's different from the joint venture providing support to the AWU for it to hire an
It is,
organiser.
and it's a departure from the strategy that said no non-working delegates.
Yes. Were there non-working delegates in the end?
No.
So, if that was being discussed at this meeting, to your knowledge, it didn't proceed?
To the best of my knowledge, yep.
And then, can you come to the next page? And I know you're not recorded as an attendee at this meeting, but it's only a few days later. It's the 14th of December, and the first one was the 10th. So this is Mr. Resnevecki's note of a discussion on that day, and it seems that the participants in the discussion were Mr. Shorten, Mr. Mellom, Mr. Winter, and presumably himself.
Yep.
That is to say, Mr. Resnevecki. And then he has an entry in about the 5th line, BS, presumably Bill Shorten, talks about matters that were being propounded, and then says, among other things, 1 industrial officer and 3 organisers, open round bracket 1 OHS. Do you see that?
Yes.
Now, you weren't at this meeting, I take it?
No.
And did Mr. Resnevecki pass on to you or discuss with you what he discussed at this meeting?
Not that I recall.
He was, at that stage, presumably in the process of taking over from you?
Very much so, yep.
But you're not able to recollect on whether any discussion you might have had with him about this proposal that was apparently being propounded on the 14th of December?
My recollection of the handover is that it was fairly brief. The moment that Julian was in the role, the the process didn't require both of us to be involved, and he didn't need my supervision. So I sort of said, over to you, and off you go.
All right, so you may have indeed, if you were involved on the 10th, is it possible that you had ceased your involvement in a substantial sense anyway by the 14th?
That sounds reasonably accurate to me.
Right. In any event, you can't shed any light, as you sit here today, on who said what at this meeting, or whether what the context of those discussions were.
Well, I'd only be drawing conclusions from the file note.
Right. And is your answer the same in respect of the document on page 25?
Yes.
And just for completeness, just have a look at 26 and 27. Is your answer the same there? We're now into February, March.
Yeah, exactly the same.
You're clear in your statement that there was no claim made by Mr. Shorten that the joint venture should pay for the enterprise agreement?
Yes.
You say that on page 4?
Yes.
And I just want to put some other evidence to you for your comment. Mr. Ralph gave some evidence. And he said words to the effect that now, of course, just to put it in context, he, of course, became project director in September 06 or thereabouts.
Certainly well after the industrial instrument was put to bed.
Yes. And he said that his understanding, at least, was that the payments that were being made were in return for an agreement to the EBA. Do you agree with that?
I don't think that's a fair characterisation of the history at all.
Right. And he'd said, at another time, he said, I prefer to put it that the payments were the consideration that was agreed for us to pay the union in exchange for the agreement to the EBA. Is your answer the same?
I don't agree with that.
And he says, and the reasonable management of industrial relations from that point forward for the rest of the project.
I don't agree with that either.
I'll just come back and ask you something about the discussions that you had with Mr. Shorten back in the latter part of 04 when this first came up, and he talked about, on your recollection, raising the question, he raised the question of payment for a full-time organiser. Did you have concerns at that time that, as it were, the negotiations had shifted? Let me try and put that in a bit more context. When you sat down to negotiate with him, he's negotiating on behalf of the members of the AWU who would in due course be employed on the project.
That's one way to characterise it, yeah.
Well, is there any other way of characterising it?
Well, he's not really representing any employees at that
At
stage.
that stage, because it's a greenfield.
Yeah.
Yeah. But in any event, that's, in a sense, he's looking ahead towards a time at which persons would be employed on that project.
Yes.
And at that time, he'd raised the possibility of the joint venture paying the AWU for an organiser.
Yes.
On your memory. And at that moment, when that came up, did you have any concern that the ground had shifted and he was now negotiating on behalf of the union rather than the workers? Or was that not something that went through your mind?
I wouldn't say that went through my mind for the reasons that I outlined earlier, in that I could understand why he would look at that from his perspective.
Commissioner, with respect, it might be better if the witness is asked whether something was said or he observed something. That might be evidence rather than simply a bland question about, did you have a concern?
Mr. Stolger?
Well, I was really exploring a different topic. I think the witness has said what he can say about what was said at those meetings, unless, of course, there's anything else he can add to the evidence he'd given before. I really was going to come at a slightly different topic, and that is to, well, I won't foreshadow it in its completeness, but the question I asked has relevance to that topic.
Yes, I think I'll allow the question.
Did any concerns go through your mind about that?
Only minor issues, which I covered off earlier, which is it's unorthodox. It's not part of the agreed strategy, so it would need to go back up the line for some kind of discussion. But as I said earlier, I also saw that there may be circumstances in which the arrangement might make sense for the company.
Well, it would make sense in terms of the matter that you advert to in your statement, is it? That on page 4, perhaps among other things, beginning in the second paragraph, you say, on the other hand. Is that why you say it would make sense?
Yes.
Ensuring a consistently high AW presence on the project would be a component of managing the CFMEU.
Yeah, if the CFMEU were not party to the side agreements.
Right. And so far as you were concerned, the arrangement would go back up the line to your superiors. Was that the idea?
Well, if we'd ended up agreeing to fund an organiser, that was never contemplated in the strategy paper that had been approved by both John Holland Tees and the parent company of both. And it would be normal practice that if we were going to make such a significant variation, you would want to put it up the line so everyone understood what we were doing and why.
Yes, nothing further. Thank you, Commissioner.
Dr. Hanscom, any questions?
Thank you, Commissioner. Mr Sass, it's the case, isn't it? I think this is uncontroversial that once you'd handed over to Mr Resniewicki in about the middle of December 2004, you were not really concerned with industrial relations or employment issues. Is that the case?
Largely, I knew that the project was in very good hands.
Yes, you had a lot of regard and still do for Mr Resniewicki, don't you?
I do.
And he's a very able man in his field.
He is.
And you would indeed trust his judgment on matters of industrial relations.
I would.
Mr Resniewicki,
Yep.
Thank you very much. I'll practice that. Mr Resniewicki reported directly to the joint venture board, did he not? Not to John Holland or to you?
No, Mr Resniewicki would have reported to the project director, initially Mr Herbert, then Mr Ralph.
Okay, but not to you?
No.
No. And indeed, it's actually the case, isn't it, that once the EBA was signed, you had no further involvement in those issues?
My involvement stopped well before the Greenfield was finalised.
Yes.
There was that period we discussed of the 3 months in the commission putting it together, which I was out before then.
Yes, that's right. And indeed, just as you have a high regard for Mr Resniewicki, you also have a high regard for Mr Mellom, do you not?
I do.
And I think you've said to the Commission in another forum that he always acted only in the interests of the workers, not himself.
Yes, that's my dealings with Mr Mellom since probably 2000. I found him a very good union official to deal with, and his word is his bond.
Yes, and he was only acting in the interests of the workers, was he not?
In my dealings with him, yes.
Yes. Now, you don't know, do you, if any... I'll withdraw that and take it a bit at a time. Councillor Sisting took you to various invoices, do you recall that?
I do.
I don't want to take you through them because none of them is addressed to you. They are all addressed to Mr Resniewicki. Agree?
Yes.
You don't know of your own knowledge, do you, whether any of those services were or were not provided?
No, I'm just surmising about what the wording and what normal practice is.
Yes, good word. You are surmising, aren't you?
Yep.
You have no knowledge of whether any of those services were ever provided.
That's true.
And you have no knowledge either, do you, of whether there were in fact purchase orders raised for any of those services, do you?
Except that the PO number would be on the invoice.
So you infer that because there's no purchase order number on the invoice that you saw on the image, there were in fact no purchase orders raised. Is that your evidence?
Well, the accounts payable system wouldn't let it through.
Sorry, perhaps it wasn't a clear question. Is your evidence that you have inferred there were no purchase orders raised because you don't see a purchase order number on the invoice?
Yes.
So it follows, does it not? You have no knowledge of whether or not a purchase order was raised for any of those services.
Yep, sure.
Right, isn't it? You don't know.
No?
And indeed, why should you know? You were not dealing with that. Correct?
Correct.
So, yes, nothing else, Commissioner.
Thank you, Dr. Hanscom. Mr. Cleland?
Commissioner? Mr. Sass, you were asked a question by Mr. Stoljar just towards the end of your evidence regarding the funding of an organiser and the need, if there was such an arrangement, for it to be put up the line. What does put up the line mean?
So you might recall in Mr. Stoljar's earlier questions about the strategy that was, the industrial relations strategy document that was prepared for this project. A document like that provides you, if you like, with organisational authority to go and do and agree certain things. That document did not contemplate the company paying the costs of an organiser for the project, and therefore it would be appropriate to go back to the people that provided that authorisation and tell them that you propose to do something different.
And if I understood your answer correctly, no such proposal was ever put up the line by you.
Correct.
Back in June of this year, Mr. Sass, I understand that you attended for what's been described as a private interview with members of the Royal Commission staff.
I did.
And could you tell us, please, just how that came about?
I think I was contacted on my mobile phone by one of the solicitors that are working with the Commission to ask me to come and have a meeting with them.
Do you recall when it was that you were first contacted?
Well, obviously before the date of the interview, maybe 3 or 4 weeks prior to that.
And were you provided anything in writing, Mr. Sass?
At the interview stage?
Prior to the interview?
No.
Were you asked to provide anything in writing at the interview?
No.
So were you informed what it was that those who'd contacted you wanted to speak to you about?
Yes, I think my memory is that it was to do with this project.
And any particular aspects of the project?
Well, I'd assumed, given what had been in the media, that it would relate to this $300,000 payment. So
for several weeks prior to attending the interview, you at least, your state of mind was that that's at least one of the things that you would be asked about?
Yes, I expect so.
And no doubt you turned your mind to that issue and tried to recall as much about it as you could.
Not that much. I had sort of assumed that as part of the process that all of the relevant documents, file notes, emails, electronic documents would have been recovered and would be part of the investigative process, and therefore I sort of assumed we'll get all that together and then work out how we reconstruct the history.
So, for example, you gave an answer early today, or several answers, about some meetings which occurred in early December, around about the 10th and the 14th of December, one of which appears you attended, one not, and there were some handwritten notes of Mr. Rezneveski.
Yes?
Yep. So was that the sort of thing that you were thinking that you might be provided with at the interview?
Oh, no, I expected a lot more than that.
Okay. Just dealing with those two handwritten notes, I think it's your evidence, is it not, that those conversations would have occurred, those meetings occurred after you had been informed by Mr. Shorten or somebody else on behalf of the AWU that they wish to involve the CFMEU on the project?
Yes, so the note on the 10th makes it clear there's a reference to John Cummins and Tommy Watson and a couple of other CFMEU officials. They wouldn't be there otherwise.
See, I just ask you in relation to that, you, pardon me for a moment, in giving your answers at that interview on the 29th of June 2015, you said at page 6 of the interview at line 25, this was with regard to the in-principle agreement, you said that all of that was agreed to and everything was running swimmingly along, and we were probably at about sort of towards Christmas Eve of 2004. And then a couple of days later, he rang me up and said, oh, I have to bring the CFMEU in on this deal.
Sorry, page 25.
At page 6 of the transcript of the 29th of June 2015.
Yep.
Right? Now, at that stage, to the best of your recollection, that information was provided to you by Mr. Shorten sometime after Christmas Eve 2004.
No,
Just deal with this. Line 25 through to 31, I'm assuming that you weren't deliberately telling an untruth then?
No.
Good.
This is
So was that the best of your recollection at that time?
at that time.
Good. So when you took part in this discussion with members or representatives of the Commission, your best recollection was that the information regarding bringing the CFMEU in on the deal actually post-dated Christmas Eve of 2004.
Yes, and that's not a very accurate recollection.
Did you tell the people who were interviewing you that you had any doubt about that issue when you gave that answer?
Maybe not explicitly, no.
Can you show where implicitly you suggested that in
Well,
that answer?
I left the interview.
Just point to where it is in relation to that answer that you conveyed explicitly or implicitly that there was some uncertainty in your answer.
Well, I can either go through the document, which might be a waste of the Commission's time, or I can tell you that at the end of the interview, I said that I would go away and formally try and structure my recollections of the entire episode, bearing in mind that my involvement ceased a decade ago, by sitting down carefully and outside of a formal interview situation, trying to reconstruct dates, times, conversations as best I could without any supporting materials.
So when you made that offer, was that what produced the signed statement of the 7th of August?
Yes, that's my best recollection, sitting in my study quietly trying to remember exactly what happened and who was doing what.
All right. When you gave the answers that you did on the 29th of June 2015, can we take it then that without the benefit of documents, you were giving the best of your recollection?
What documents do is...
Just answer my question. Were you giving the best of your recollection on that occasion?
At that time?
Yeah. Well, when you say at that time, it's not just that you were giving the best of your recollection, you were making statements, some of which were quite emphatic, were they not?
Possibly. But that's a matter of opinion.
All right. Well, if we could perhaps do it this way. Could you turn to page 11 of the transcript? You'll see at line 9 that Mr. Stolzer had asked you a question. It reads, okay, and then, well, ultimately the two EBAs, as it turns out, get approved and get renewed, and the job starts and it's a success. How did the agreement to pay the $100,000 a year come about? And your answer is recorded as, so the one discussion I'd had a very loose discussion with Shorten about how we would, this is before he brought the CFMEU into the job, how we would manage an AW-only project. And he had made a suggestion to me that the best way to buttress the project would be to have a full-time organiser, AW organiser, that was dedicated to the job. And that's where your 300 grand comes from, so 100 grand a year is his salary plus a car. Now, firstly, do you accept that you gave that answer?
I do.
Yeah. And do you still adhere to that answer?
Largely.
Mm-hmm. What would you change about it, Mr. Sass?
Well, I think the statement that I prepared is a more structured and a document, and it's been prepared with the benefit of sitting down quietly and trying to recollect in detail what happened.
What additional document did you have available to you when you made the statement that you signed on the 7th of August that you did not have on the 29th of June 2015?
I had no document, and I had the knowledge that no documents were going to come my way.
Right. So there was no document you saw. So what you did know, though, was that Mr. Shorten had given some evidence. Did you not?
Yes.
Yep. And had you been provided with a transcript of that as at the 7th of August?
I cast an eye over it on the online.
Question, had you been provided with a transcript? Yes or no?
What does that mean? Does it, if it's provided online and I look at it, does that mean I'm provided with it?
Well, I can ask you a different way. Did you have access to a transcript?
Yes, of course I
Right.
did.
And had you read it?
I skimmed it.
Right. Did you skim past those parts that dealt with Mr. Shorten's dealings with you?
No, I read those.
Right. Further on at page 11 of the transcript, Mr. Stolzer, after your previous answer that I'd taken you to, asked you this: best way to buttress project is to have AW organiser. Your answer is a dedicated organiser or an organiser spending most of his time on the project. Now, I'm not in favour of that for a second because I don't really care who's paying for the organiser. They're a pain in the arse. I'd rather have my management manage the project. So I was very, very vague about all of this and never committed to it at all right through the process. That sentence that I've just read to you, so I was very, very vague about all of this and never committed to it at all right through the process. That was a truthful statement, was it not?
Yes.
And it reads on, and then when he brought the CFMEU in, I regarded that particular discussion as being all bets are off anyway.
Yes.
Now, I've taken you to an earlier reference to when he brought the CFMEU in, and you say that as at the 29th of June, your best recollection was that that was post-Christmas 2004. Is there some document or some other evidence that suggests to you now that it was earlier than that?
Oh, yes. Julian's file note from the 10th of December makes it abundantly clear.
Prior to seeing the file note, other than that?
No.
Right. We'll just go back to, for the sake of the sequence, we just go back to page 5 of the transcript, and I'm content for you to follow this as I take you to it. What you were setting out at page 5 was an industrial relations strategy, and you explained, if you like, what the origins of that were because of, amongst other things, blowouts and various unsatisfactory aspects of other major projects, including Spencer Street.
Yes.
Correct? And the strategy that you designed was twofold. The first was to, in effect, provoke the CFMEU into unlawful industrial action, was it not?
It was.
Yep. And in your mind, that was an acceptable industrial relations tactic?
Absolutely.
And secondly, the strategy was to, in effect, threaten the AWU or representatives of the AWU that if they didn't agree with the flexibilities that you were proposing, then you would, or the company or joint venture, would deal with individuals on the basis of AWAs.
Yes.
And it's true that you, in fact, had no intention of doing that. That was a negotiating strategy, was it not?
Correct.
Did you think it was all right to threaten to do something in those negotiations which you had no intention of doing?
We're talking construction industry, industrial relations in Victoria, not
Asking
the
you
local
question,
childcare centre
did you
here.
think it was all right?
Absolutely.
So a false or deceptive statement of that kind, in your mind, was
Whoa.
a legitimate negotiating strategy, was it?
I had the legal right to mobilise a workforce on AWAs. Had I not succeeded in convincing the AWU to give me what I needed, then we will almost certainly have gone down that path. Now, whether the whole project was built under AWAs is a separate question, but I think you need to understand the industrial relations environment in which you're dealing.
I thought you just told the Commissioner that you had no intention of actually going by way of AWAs, that was in effect a negotiating strategy. Was that true or not?
It is a strategy. The strategy explicitly...
Was that answer true, Mr. Sass?
I had no intention of building the whole project on AWAs, and I had no expectation that I would have to, because I thought my strategy was sufficiently robust that I would get the agreement that we needed.
As you put it in your transcript of the 29th of June 2005 at page 6, line 8, Commissioner. Now, whether or not we were prepared to do that or not, it's a moot point. All I needed to do was to get Shorten to believe that I did. That was your state of mind?
Yeah.
And you go on there to say, and he did. He swallowed it beautifully. That was your assessment of what had occurred. You'd put the proposition up and Mr. Shorten had accepted it.
In principle, yes.
Yep. At page 12 of the transcript, at line 15, Mr. Stoljar asked you this, line 15, Mr. Stoljar, did he say, that's a reference to Mr. Shorten, I'd suggest, did he say that 100 grand would be the salary plus car? Answer, no, I'm just putting 2 and 2 together in terms of the numbers. Oh, did he talk about a specific number when he, and you cut across him and said, no, he did not. Mr. Stoljar said, okay, you said no. Now, there's nothing equivocal about those responses, may I suggest, Mr. Sass, is there?
No, I don't think so.
And by those answers, you were conveying and intending to convey that Mr. Shorten had not mentioned a specific number or figure.
That's correct.
Yep. If we go further into this transcript, if I might, at page 13, the attraction, if I can put it that way, or the theory that you were contemplating was that if an organiser was put in place and that person was an AWU organiser, if you just attend to the question and I'll direct you to the transcript in a moment, But the presence of an AWU organiser would strengthen the notion that this was an AWU project, correct?
Partly.
And also avoid the creation of a vacuum where the CFMEU may seek to step in and have one of their delegates, for example, on site.
That's more important from my perspective, yes.
And that was, in effect, what was going through your mind when you were considering the desirability of the organiser or not?
Yes.
Thank you. So, at line 20, you explained that thinking of page 13, line 20. So what the argument for a paid organiser is that if we don't have someone on the job, it'll be a vacuum and the CFMEU will come and fill it, is the logic. And Mr. Stolzer said, oh, I see. And then you, at line 26, said, now that's not an explicit discussion I had with Shorten. That's the logic that the IR club would be going through your head when you're having that kind of discussion. Now, was that correct?
Yes.
And they were accurate answers by you?
Yes.
And you then returned to the question of whether there had been an agreement. And again, can I suggest, emphatically said at line 31 of that same page, so there was no agreement at all to actually do it.
Meaning I hadn't agreed to it formally.
Well, you said there was no agreement at all to actually do it. What you meant was there'd been no agreement between you and Mr. Shorten.
Well, if I don't agree to something, there's no agreement.
Has to be right. Okay. You went on to say it was raised. I didn't like it, not least because I don't accept the theory that says, you know, if there's a vacuum, it's because my frontline management aren't doing their jobs properly, and I'll change them out or train them rather than have a union fill the role. Just stopping there. So the strategy was not one that you were actually attracted to.
It's not my preferred option.
Right. You said that you didn't like it, but not least because you don't accept the theory that says if there's a vacuum. So do you accept it or not?
Well, the reference to the IR club is conventional IR thinking is that you can't have a large project without some kind of union presence. And that's often a criticism on employer sides that if you have AW-only jobs, they don't organise them effectively and the CFMEU comes and fill the vacuum.
Right.
My preferred position is that the company has sufficient capability in its frontline leadership that it's those people that manage blue-collar workforces and do so without the need for any third-party intervention.
At line 38 of that same page, you continued your answer. So by the time this whole process goes into the commission, I assume that's the Industrial Relations Commission you're referring to there.
It is.
You'd handed things over pretty much to Julian, full stop. That would be Mr. Reznerveski.
It is.
Thank you. And you then added that similarly Bill had flicked it all onto Caesar, who was his up-and-coming protege. And that was an accurate statement?
That's I'm looking at the organisation and giving my view.
You can only speak from your knowledge. To your knowledge, that's what had occurred at that stage, correct?
Correct.
And again, the last two lines on page 13, lines 46 to 47, you again went back to the issue. So the payment issue was never, ever agreed at the Shorten level at all.
Yes.
Now, I asked you before about emphatic statements or absolute statements, statements of certainty. It doesn't get much more emphatic than that, does it? So the payment issue was never, ever agreed at the Shorten level at all.
Yes, the idea of paying the $300,000 without an organiser.
Yep. I beg your pardon? So the payment issue was never, ever agreed at the Shorten level at all.
Yeah, so if you look at the tone of the interview, the discussion from lines 26 down to 47, it's talking about the need for an appointment for an organiser funded by the company.
Yep.
Right, and that was not agreed. We've had this discussion a little earlier.
Yeah, so there was no agreement at all to actually do it. That was to have the company pay for an organiser,
Correct.
an AWU organiser.
Yep.
Sentence, so the payment issue was never ever agreed at the shortened level at all. That's what that refers to.
Yes.
Right. So, Mr. Stolzer, over the page at 14, asked you this. So what level was it agreed at? Now, just stopping there, that question seemed to assume that there was, in fact, an agreement about payment of $300,000. Yes?
Well, the invoices suggest that.
You didn't have the invoices at this stage, did you? On the 29th of June 2015?
I was shown them as part of this discussion.
Were you?
It's my recollection. I'm sure that can be confirmed.
Because you were asked when you first became aware of the so-called $300,000 deal at line 43 at page 15, and your answer was, perhaps I should put the question to you fully, line 43, when did you become aware of the 300,000 deal, if that's what it was? Answer, when it hit the paper. Oh, you hadn't heard of it before then? Answer, I had had some suspicions during the life of the project that things were happening. Were those truthful answers, Mr. Sass?
They were.
I'll just ask you to go forward to page 28 for the moment. This same interview of the 29th of June. Page 28, Mr. Stolzer at line 37, and this was coming towards the end of the interview. By the way, can you tell us how long the interview actually took?
Maybe an hour, maybe a bit more.
At line 37, Mr. Stolzer asked you this, all right, well, look, anyway, is the short point, though, that from your point of view, you didn't know about this $300,000 payment or arrangement. When I say $300,000, it seems roughly $100,000 a year for the life of the project, until you read about it recently in the newspaper. Your answer is recorded as follows at line 44, pretty much yes. And you know, Shorten, bless his cotton socks, never asked for, you know, he flagged an organiser and that was it. It was never agreed. Was that a truthful statement, Mr. Sass?
Yes, it is.
Okay. And it's a statement that you adhere to?
Yes.
The figure of $300,000 was a figure, it seems from your answers during this interview, that you, in effect, arrived at in your own mind by making some sort of calculation of the wage and fringe benefits, or salary and fringe benefits, that might be paid to a union organiser.
It may have been illuminated by a conversation with Mr. Shorten. I can't accurately recall that.
May have, may not have.
May have, may not have.
Right. Because it may well be that the figure is entirely a matter of your own surmise as to just what figure might have been involved if indeed the joint venture decided to pay an AWU organiser.
It would be that order of magnitude.
Yeah, because earlier on today I think you suggested an amount of $75,000 per annum in an answer to Mr. Stolzer.
As a salary component?
Yes, and then added a car. That would be a brand new car each year, wouldn't it?
Oh,
To get to 100,000.
Well, depending on how you value it, superannuation, all the on costs that go with employing somebody.
But if someone said $75,000 a year, the additional cost of supplying a car that is to the joint venture, wouldn't be $25,000 per annum, would it?
Yeah, but as a rule of thumb, the on-costs that go on top of a salary are 25 to 35%, depending on how you structure it.
When you had the further interview with Commission staff on the 7th of August 2015, page 7, Commissioner, you were asked this question. Turn to this
Mr.
if
Clement
you...
might just give Mr. Sass an opportunity. And Mr. Sass, it's going to be on the screen in front of you. You don't need to go through
Oh,
the
okay.
papers.
Yep.
Mr. Sass, I was just about to say, you can turn to, if you have the transcript, page 7, line 7. Do you see that?
Yes.
Correct me if I'm wrong, but did you see the problem there is twofold? One is that you actually have to pay, someone has to pay the wages of the non-working delegate, and your answer is recorded as yes. Total cost of employment back then for a non-working delegate was probably around $130,000 to $140,000 a year. And then you went on to say the really important issue is disruption. Now, should we differentiate between that sort of salary package for a non-working delegate as opposed to a non-working organiser?
Absolutely. Your average construction blue-collar worker is earning generally significantly more than an AW official.
So a non-working delegate in those circumstances, are you saying that that would be a CFMEU delegate?
Would be any delegate under a standard industry pattern agreement that was in place in Victoria at that time.
Right. So that would be $130,000 to $140,000 a year. Would that have included a car?
No.
No. Yep. I was going back to the interview, Mr. Sass, of the 29th of June, and at the top of page 29, line 1 and following, this issue again is picked up, and I think you might have already answered these questions, that this may well have been you surmising that a figure of $100,000 per annum would be somewhere around the mark, and if that was for 3 years, that's how you'd get to 300,000.
So you're looking at line 30.
Yeah, line 1 at page 29 through to about line 14.
Yes.
You agree?
Yes.
Thank you. All right. Now, I'll just ask you a little bit about your attitude to industrial relations. It would be fair to describe you as someone, in terms of your IR stance at least, you would favour deregulation of the Australian industrial relations system?
Well, certainly a different framework to the one we've got now.
But the answer to my question, is it a yes?
That deregulation is a benefit?
Yes.
Yes, without question.
Abolition of award payments?
That's a very big step from deregulation to taking out the award system.
Yep. But is it something you favour?
My view is that the current system of labour relations is premised on an assumption about bargaining inequality between employers and workers, which doesn't hold true in the modern world.
So you would prefer individual employment contracts?
I would like to see much greater flexibility between workers and employers.
And a lowering of minimum wages?
I would not agree to that. I think the minimum wage debate is a complex and philosophical one.
Yep.
It's not a question about lowering, it's about flexibility for people to move up and down around it.
I ask these questions because I think from time to time you've spoken at the HR Nichols Society.
Twice, once in person and once by proxy.
Yep. And is that an organisation of which you are, or a society of which you are a a member or in some way affiliated?
I'm not a member. I was asked to give a paper there at the end of last year to explain to the people who were attending and hopefully a broader audience the very, very significant benefits that had accrued as a result of the Victorian State Government's Construction Procurement Code.
The speech that you were giving in November 2014, you were actually speaking against the Victorian Labor Party industrial relations policy, weren't you?
Very much.
And you would describe yourself, I'd suggest, as somebody whose philosophy accords with that propounded by the H.R. Nichols Society.
No, if you'd actually read the document you'd referred to, you'd see very clearly that the tenor of it is that the key to obtaining labour productivity in construction is to manage the contractors, not the union.
Yep. Do you, in terms of the question I've asked, though, in terms of your philosophy, would you say that it accords with that propounded by the H.R. Nichols Society?
In some parts, yes. In some parts, no.
All right. You are also somebody, I think, who very much supports the role of the Australian Building and Construction Commission.
Absolutely.
You have, I think it would be fair to say, very strong views on corporate and union governance.
I do.
And as an officer or former officer of a number of public companies, you have taken a stance, have you not, against corrupt practices?
I have.
Yep. You, for example, have brought alleged corruption within Leighton's to the attention of various regulators and other authorities?
I brought to the attention of the senior management and the board.
Yep. You are somebody who would in no way, shape or form associate yourself or engage in corrupt or improper practices.
No.
Yeah. Mr. Sass, after the 29th of June, I think we've already established that you became aware of Mr. Shorten giving evidence before this commission, and you accessed the transcript of his evidence. Is that right?
I did.
Yep. And we know that's logically post 8 and 9 July of this year, but can you tell the Commissioner when that actually occurred, when you accessed the transcript?
Pretty close to the time that Mr. Shorten was examined, I think.
Mm-hmm. And the statement that you then made and has been tendered this morning, or at least, yes, tendered this morning in evidence, it's headed the East Link Project, Industrial Relations, Background and Payments to the AWU. That's a statement that you drew up yourself?
Yes, it is.
And is it a statement that essentially reflects what you had said by and large in your answers on the 29th of June 2015?
It was an attempt to try and put a more coherent position together to assist the Commission rather than coming at it cold in an interview process.
Yeah. Are you able to just tell the Commissioner in what way the content of that statement differs from the answers that you gave in your interview of the 29th of June 2015?
I think substantively there's no great difference. I just think it's laid out more coherently.
Okay. And would you give a similar answer in respect of the private hearing that was conducted on the 7th of August 2015?
As far as substantive issues are concerned, yes.
Yep. So really, in order to assess what you say about the arrangements with Mr. Shorten and in particular, any arrangement regarding an AWU organiser being employed by the joint venture, we can look to the answers that you gave on the 29th of June 2015 and they reflect, as best you're able, the accurate detail of what occurred between you and he.
The discussion was never about the JV employing the organiser. It was paying the AW the costs of them employing the organiser.
I just want to tease that out with you. That was something that you were explaining back in June of 2015, before Mr. Shorten gave his evidence, was it? That it was about the joint venture paying the union to him so that they could employ the organiser on site.
That's always been what it's about.
Yeah, okay. So with that qualification, but what you've explained then on the 29th of June, we can take that as your evidence.
Well, I think all three sets of documents are substantively similar.
Yep.
Just indicate, Commissioner, if Mr. Cleland is going to make a submission in due course that there are inconsistencies, then as a matter of fairness, he should put that to the witness for his comment. If he's not going to make that submission, then he doesn't know.
I suppose what I'm really asking you is this, Mr. Sass. When did you first receive the transcript of the interview of the 29th of June 2015?
Via an email maybe a week or so ago. I could confirm that.
But after you had made your statement on the 7th of August?
Yes.
So you didn't have a copy of the transcript then?
No, I didn't.
Right. So have you had the opportunity to compare the transcript of the 26th of June 2015, your statement, and the transcript of the private hearing on the 7th of August?
No, I haven't. I'm quite busy.
Right. Mr. Cleland, you said 26th. I think you meant 29th of June.
Thank you, Commissioner. All right. You heard Mr. Soldier say if I was going to make some submission that there is an inconsistency between the two interviews and the statement, then I should put it to you now. What I'm really asking you is whether in your mind, having read the three of them, is there an inconsistency?
No, I think the substantive recollection is quite consistent. There are obviously the difference between having an interview where you're being asked a series of relatively unstructured questions.
Sure.
Is a different process to me sitting down and trying to coherently write down my recollections.
Yep.
And over the top of all of this is that we're talking a decade ago as far as I'm concerned, and I don't have the benefit of the notes and related documents. So yes, we're working off my memory. You're not going to get in three separate types and times of discussions a verbatim recollection.
As far as you're concerned, Mr. Sass, is there anything improper for a union to request an employer to pay for an organiser on site?
No.
Pardon me for a moment, Commissioner.
Thank you. Mrs. Hogan-Doran, any questions? I'm sorry, Mrs. Hogan-Doran. Mr. Cleland is taking
Subject
instructions.
to what Mr. Cleland next says, I won't have any questions.
We have nothing further for Mr. Sass, Commissioner.
Well, nor is Mrs. Hogan-Doran. So, Mr. Soldier, anything?
Sorry, but I thought this had been done. But Commissioner, might we tender
Mr. Cleland, you have vast experience of the Commission. Rightly or wrongly, the rule is that Mr. Stoljar does the tendering, but I'm sure he will tender things that you want him to. What do you want him to tender?
the transcript of the 29th of June 2015 and the transcript of the 7th of August 2015, just for completeness, which were interviews between this witness and Commission staff. Commissioner?
Yes. Well, the transcript of the 29th of June 2015 will be SAS MFI 3, and the transcript of the private hearing of the 7th of August will be SAS MFI 4.
Can I just indicate, Commissioner, that the version of the interview that Mr. Cleland was asking questions about and has now just been tendered is the one that
Is uncorrected.
predates the minor corrections.
Yes.
If there's any issue about them, I don't know if there will be, but if there is any issue about them, then that perhaps can be debated. But in due course, the corrected version could be replaced for
Yes,
the
well,
one
I've
tendered
written
now.
on my copy that SAS MFI3 should be read in the light of Arnold Bloch Liebler MFI3, and I've made what are described as the more substantive changes, numbering 2. But in the long run, perhaps it might be better to substitute the corrected version for the present one.
No,
Yes, Ms. Hogendoren.
Mr. Soldier, Commissioner, I've been shown the proposed corrections to the transcript. I haven't had an opportunity to take full instructions in relation to them. I understand, though, from a brief conversation with Mr. Sass that there is one matter that he doesn't believe is a fair representation of his recollection of the interview, but it is not a matter that goes to any substance of the matters that Mr. Cleland has put or Mr. Soldier has put.
Very well.
Thank you, Commissioner.
Any questions, Mr. Soldier?
Just a couple of things, Mr. Sass. I'm still just trying to pin down exactly what the position is in respect of page 12 of the interview. You were asked some questions about this by Mr. Cleland. If I just take you to that page again, and I asked you at line 15, did he, that's Mr. Shorten, say that 100 grand would be the salary plus car? You say no, that was just, I'm putting two and together in terms of the numbers. I say, did he talk about a specific number when no, he did not. Okay, no. So you, and Mr. Cleland put to you something like, well, that's an unequivocal response. Now, can I just take you back to your evidence this morning? And at some point this morning, I don't have the transcript reference, but my note is that you said words to the effect that during these discussions, a number was discussed, and then you said whether he came up with it or whether I did, 100,000 was part of the discussion. Now, is that your evidence, that 100,000 was part of the discussion?
I can't accurately or clearly recall whether or not we talked about the precise number, but we talked about the company funding the costs of an AWU employee to be deployed full-time on the project. And I, either in my own mind or on the basis of a discussion, concluded that that was going to be 100,000 a year plus or minus 10%, because that's roughly what the market for AWU officials is. I don't recall I couldn't say with any great level of confidence that Mr. Shorten said it will cost you $100,000 a year, but it was crystal clear that the request was that we pay the costs of an organiser, which in a practical commercial sense is largely the same thing.
What do you mean it's largely the same thing? You mean it's largely the same thing as 100,000?
That's the cost of it.
My understanding of what you've just been saying, Mr. Sass, is when you talk about an organiser, you say to yourself, well, they get about 75,000 and then they get a bit of superannuation and then they'll need a car. And if we multiply 75 by 25 or 30%, we end up with around 100. That's corresponds with your thinking process at the time.
Yes, it does.
Yep. Yes.
Can I just take you to a passage in your private hearing, which has now gone into evidence. Sorry. Excuse me just a moment. Can you just have a look at page 34 of your transcript of your private hearing?
Yep.
And I was asking you, this is on the 7th of August, and I asked you some questions about some things that Mr Shorten had said in his evidence, just for your comment. So line 26, I say, for example, I asked him whether he had discussions with you about a proposition pursuant to which $100,000 would be paid per year with reference to an organiser, and he said no, that's not his recollection. And then he said the services which I charged for, which the union charges for, could always be explained by reference to functions performed for training delivered, and this is an entirely sensible workplace relations. That's taken from Mr Shorten's evidence. And I said, what do you say to that? You said, my recollection is very, very clear that the concept of funding an organiser was a core part of the initial discussions that he and I had. So I don't agree with what you've just read out. And secondly, we don't need to buy training from the AWU in any circumstance. Well, the second point you're really dealing with, Matt, is the subject of the invoice. But looking at the first point, your recollection on the 7th of August was very, very clear that the concept of funding an organiser was a core part of the initial discussions that the two of you had. Is that still your recollection?
Yes, it is.
But you say that although...
Mr Stolzer, not lead the witness, please.
Well, as I apprehend your evidence earlier, you say firstly...
Still leading the witness, Commissioner.
I haven't asked the question yet. How do you know?
That was enough.
You've just told us that you thought that it was very, very clear that the concept of funding an organiser was a core part of the initial discussions. At some point, and we think from the diary notes...
Commissioner, with respect, it's 3 guys that counsel assisting has had in it. It's re-examination. Perhaps he could just ask the question in a non-leading way.
Well, given many of your questions were leading. But anyway...
I'm allowed to do that.
Well, it's not room for the anyway. Mr Sass, I just want to ask you this. You had a look at page 23 of SAS MFI2, which was the note about the 10th of December.
Yes.
It was clear that the CFMEU had come into the picture by that stage.
Yes.
Is your evidence that the arrangement was off the table from your point of view as at that time?
Categorically.
Nothing further. Thank you, Commissioner.
Now, is there any objection to Mr Sass being excused from further attendance?
Not on my account.
Mr Sass, you're excused from further attendance on the summons that you've responded to today. You can leave the witness box now. Thanks very much for your attendance. Yes.
The next...
May I also be excused from further
Yes,
attendance?
Mrs Hogandoran, you may leave.
Thank you.
Now, we're going to depart from the order slightly, Commissioner, because Mr Ralph is flying to Perth tonight, so we may endeavour to deal with him and see if he can get away quickly.
Yes, by all means.
So I call Mr Ralph.
Do you swear by Almighty God that the evidence you shall give in this Royal Commission shall be the truth, the whole truth, and nothing but the truth?
I do.
Have a seat, Mr Ralph.
Could you tell the Commission your full name?
Gordon John Ralph.
You're a resident of New South Wales,
I am.
and you're currently Executive General Manager of Projects at Leighton's,
That's right. Leighton Contractors.
Leighton Contractors. Now, you had a private hearing on...
Just one moment, Mr Stoddard. What time does your plane leave to go to Perth tonight?
I've rescheduled it, so it's not the 4:30 flight now. It's a little later.
When exactly?
5:30. 7:30. 7:30.
Yes, thank you.
Yeah, plenty of time.
You had a private hearing in the Commission on 18 August 2015.
Yes, I did.
Commissioner, I tendered a transcript of Mr Ralph's private hearing. Now,
Yes, that'll be Ralph MFI 1.
now you became involved with the Eastlink joint venture in about September 06.
September 05.
I'm sorry, September 05, and you became project director.
I did.
Took over from Mr Herbert.
I did.
And you said in your private hearing that you didn't have any briefing from him before you commenced.
No, we didn't.
Who did you report to yourself?
In a formal sense to the JV board, and then in a day-to-day sense, my senior manager in John Holland, who was my employer at the time, was David Stewart.
And did Mr. Resnavecki report to you?
He did?
He was one of your direct reports?
Yes, he was.
After you'd begun, were you told of any arrangement pursuant to which a payment would be made to the AWU in exchange for the AWU committing a dedicated organiser to the project?
No, there wasn't an AWU organiser attached to the project.
There wasn't a dedicated organiser,
No.
is that what you say? Well, were you told about any arrangement pursuant to which a sum of money was to be paid by the AWU by the joint venture to the AWU?
After I'd been on the project for some months, a cost became that was registered in the journals for the project. I became aware of that cost. I inquired. It was in Julian's area. I inquired of Julian what that cost was represented, and was told that that was a cost that was payable to the AWU pursuant to the EBA negotiations.
Pursuant to the EBA negotiations?
Yes.
Well, let's just take that in steps. What was the cost, do you remember?
The $100,000 from memory was the cost I first recognised in the cost ledgers.
Well, is that... do you mean by that? When you say in the costs register, do you mean in the accounting software that the joint venture was using?
Yeah, each of the general managers who reported to me had a specific cost centre, and their costs were monitored against the budgets that were allocated to that cost centre. Julian's was quite a small cost centre, being HR, IR and safety, and that sum of money stood out fairly clearly one month. That's when I made my inquiry of Julian as to what it was about.
All right. Do you remember when that was roughly in the scheme of things?
I can't recall exactly, but 3, 4, 5 months into the project, or into my tenure on the project.
All right, but did you have a look at the underlying invoices and the like, or you just looked at some monthly report or a monthly account?
No, I just looked at the monthly cost report for Julian's area. Had got an explanation for Julian as to what it was represented, what the cost represented, and didn't pursue it down to invoice level. Well,
when you say you got an explanation, can you remember more precisely what he said to you?
I can't remember precisely what he said to me, but it was essentially that it was an amount of money being paid to the AWU that was pursuant to, in consideration of, the agreements that have been reached with the AWU.
What agreement?
The EBA agreement.
Did you ask him how the arrangement was negotiated?
No.
Did you have any concerns about making these payments, as you saw in consideration for agreeing to the EBA?
I'd certainly have concerns about paying $100,000, but that wasn't something I was going to be able to influence. The deal had been done, and that was the amount of money that had to be paid.
Well, when you say 100,000, was it 100,000 per year, or is it one-off, to your understanding?
Well, the first payment that I came across was $100,000, and look, I can't say for certain as to when that repeated itself, but the first payment I came across was $100,000, or the first cost entry was $100,000.
Well, did you ask whether this was annual or whether it was one-off?
I can't recall.
Is this your evidence, and tell me if it is or it isn't, that you would have been concerned had you been asked to do it, but you thought that the agreement had been set up, so you had no option really other than
I had no option but to honour the agreement that had already been made.
Did you report up to the board that there was this agreement in place?
I can't recall raising it with the JV board at the next meeting. No.
Did you regard that as appropriate, that the joint venture was paying $100,000 at least in exchange for an agreement to an EBA?
Well, whether I thought personally it was appropriate or not was neither here nor there. It was an arrangement that had already been made, and that prior to my time on the project, and that needed to be honoured.
Well, when you say it was neither here nor there, you didn't see a written agreement, did you?
These things are not normally in writing, no.
What do you mean then these things are not normally in writing?
Say again, sorry?
What do you mean these things are not normally in writing?
Well, such arrangements with a union, you don't find them in writing.
Have you come across arrangements like this before?
Not personally, only by hearsay.
Well, what have you heard about?
Oh, that payments, such payments in exchange for settling either disputes or settling negotiations weren't uncommon at that time.
With the AWU or with other unions?
Just generally, I don't.
So you say you can't point to any specific example
No.
as you sit here today. But you regarded the arrangement as inappropriate, did you?
It's not something that I would have agreed to if I was there at the time, no.
You regarded it as inappropriate, did you?
I think it's inappropriate, yeah.
And you thought that at the time?
I can't say what I thought at the time, but I think now it's inappropriate. I don't think I would have had any different view at that time.
But you were the project director. Couldn't you have gone and said, look, let's at least examine the basis of this arrangement and have a look at what precisely was agreed and whether we're stuck with it?
The project at that stage was we were needing to accelerate the rate of progress of the work. The work had been proceeding without any industrial unrest. We needed to accelerate that rate of progress, and we needed to ensure that in doing that we didn't have any disruptions. And I wasn't about to do anything that would cause previous settled agreements to be brought into play and potentially disrupt that progress.
So you thought that this was a way of ensuring industrial peace?
What I thought was that the agreement that had been made had to be honoured, and that I didn't want to do anything that was going to jeopardise the projects.
But isn't that really saying the same thing in different words? You said I wasn't about to do anything that would cause previous settlement agreements to be brought into play and potentially disrupt that progress. Isn't that really just a way of saying you wanted to ensure that you still had industrial peace?
Well, absolutely, I wanted to ensure that industrial peace.
And you were prepared to honour this arrangement in order to keep the industrial peace?
I wanted to ensure that industrial peace was maintained, and the same lack of industrial disputation that had been the case on the project for the preceding 12 months remained in place, and for the duration of the project. Now, if that was all consequent of the payments that had been made, or the payment that was being made, and that agreement had previously been made, then I was happy to go along with that agreement, or willing to go along with that agreement.
Did you check the underlying invoices yourself? I think you said you didn't.
I can't recall seeing the actual invoice. Julian may well have shown me the invoice, I can't recall.
Did you take any steps to check whether or not the invoices reflected services that had actually been provided?
Look, at the time, I can't recall what investigation directly as to the invoices, the content of the invoices. I can only comment on the invoices you've shown me in these hearings.
I mean, it's not an agreement that found its way into the EBA, obviously.
No.
And you didn't expect it to be documented anywhere?
No.
You expected it to be an under-the-table, if I can put it that way, arrangement?
Yes.
And not one that was disclosed to the members of the AWU who might be working on the project, or not by you anyway?
Not by the company, no.
And to your knowledge, not by the union?
I'm not aware of the union disclosing it to its members.
Nothing further. Thank you, Commissioner.
Dr. Hanscom?
Thank you, Rob. Commissioner. Mr. Ralph, you wouldn't know at all, would you, what the union does and doesn't tell its members? You're not a member of the union, are you?
Sorry, I can't quite hear.
I'm sorry. You were never a member of the union, were you?
No.
You don't know what it does and doesn't tell its members, do you?
No.
You're just guessing. When Mr.
Guessing
Stoljar
at what?
When Mr. Stoljar says to you, you wouldn't expect it to be disclosed to the members by the union? and you answer him, you'd just make a guess. You wouldn't know.
Commissioner, I'm not sure that was, in fact, my question. I said to your knowledge, not by the union.
At page 105, line 9, I'm sorry, can I just scroll back? I may have misunderstood what Mr Stoljar said. Yes, I withdraw the question. Mr Stoljar's correct. Now, you're guessing also that this was a payment for settling negotiations or settling a grievance, aren't you?
I'm not assuming that. That's what I was told.
That there was a grievance that had been settled.
I was told when asked for an explanation as to what the 100,000 represented, that it was payment in exchange for the settlement of the industrial arrangements for the project.
Well, can we just tease that out in a little bit more detail? Initially you said paid pursuant to the EBA. That was your phrase.
Well,
That's not the same, is it, as settling a grievance?
I think that's semantics.
Commissioner, I just think there may be a miscommunication again. I'm not sure that this witness said settling a grievance. It may be that Dr Hanscom's having some trouble with the...
He used that expression in relation to matters other than this alleged agreement. He was talking about hearsay evidence about matters in the industry generally, not necessarily involving the AWU, but not the $100,000 3-year alleged agreement.
Yes.
So when you used the phrase settling a grievance, you weren't talking about this arrangement, whatever it may have been. That was a general remark of yours.
In relation to the $100,000 payment on Eastlink,
Yes.
the explanation I was given was words to the effect that this is payment in consideration for the negotiations for the agreement for the Eastlink project.
And you say, who do you say told you that?
Julian Rezanoveski.
Well, Mr Mellom says that the services that were invoiced were in fact provided, and you can't say otherwise, can you?
From the invoices I've been shown, some of the services on those invoices definitely were not provided.
What services do you say were definitely not provided?
Well, if you can show me each of the invoices again, I'll point to them.
I thought you just volunteered that you could say some services were definitely not provided.
If you could show me the invoices, I'll point to the services that I'm sure were not provided.
You can't remember as you sit there the ones
Not off the top of my head,
that you're
no.
definite about.
Not off the top of my head.
All right. I'm not sure that your bundle includes the invoices. Could the witness please be shown MFI 9 of Mr Shorten, which is probably the convenient source for the invoices. Do you have that there?
I have a folder, Shorten.
And do you have a tab marked 9.4.1?
No.
Oh, do you have pages at lower, page numbers at lower right?
I've got page numbers that go up to 250.
Yes, can you go to 169?
169. Yes,
Do you have that?
yes.
That's an invoice for training an attendee called Jason Morgan, isn't it? An OH&S representative? Are we looking at the same thing?
An invoice for $750.
Yes, but what it's for is OH&S training, agree?
So that's an invoice for five-day representative training course.
And the attendee is Jason Morgan. Do you agree?
It says attendee Justin Morgan.
Yes. Now, do you say that wasn't done?
That one I wouldn't be so sure about. That's quite specific.
Turn over to page 170.
170, yes.
20 tickets for a population forum. Do you say that didn't occur?
The forum may well have occurred. We wouldn't have been sending people to a forum, such a forum, or
So you-
sponsoring such a forum.
You give evidence, do you, that that did not occur? 20 representatives did not go to that forum. Is that your evidence?
Sorry?
Is that your
I wouldn't have
evidence?
expected to have been sending 20 people to an AWU population forum. It had no relevance to the project whatsoever.
Mr Ralph, I didn't ask what you would expect. You said, I can say definitely some of those services weren't provided.
Yep.
You said you needed to see the invoice to say which ones weren't provided.
Yep.
I want to know what your evidence is. Is it your evidence that that 20 representatives did not attend that forum?
10 years on, I can't say that those people didn't attend those that course or that forum, but that's got no relevance to the project at all, and it wouldn't have been something we'd send people to.
Well, thank you for that additional information, but the answer is no, you can't say it didn't happen. Correct? Is that correct?
Sorry?
You cannot say that did not occur. Is that correct?
I can't say that we bought 20 tickets to that forum, no.
And you can't say you didn't.
No, I can't say.
Turn over to 171A if you would.
Yes?
That's a full-page advertisement in the Australian Worker for winter 05. Do you say that didn't occur?
I can't tell you whether that did occur or didn't occur. Again, I can tell you that there wouldn't have been no reason why the project would have taken out a full-page ad in the Australian Worker. But I can't tell you whether it did or it didn't occur.
We'll get through this faster if you just answer my question. You cannot say that did not occur, correct?
Yes.
Can you turn over, please, to 174? OH&S training and Robert Johnston attended. You can't say that didn't occur, can
No.
you? Turn over, please, to 176. OH&S training of Mark Brennan. You can't say that didn't occur, can you?
No.
177, a booking for one table at the AWU annual ball for 2005. Do you say that didn't occur?
We may well have paid for a booking for one table as a means of a contribution to the AWU.
So you agree, actually, that one probably did occur.
In a form, yes.
Next page, 178, a booking for a table. I think that must be a duplication, actually. It's
Looks
the
to
same
be.
in your ball.
It's different. It's a
So
different
can I
number.
turn
Two
you
different
over?
invoices.
Oh, so they are. So there were two tables, in fact. Do you say that didn't occur?
As I just said, same comment for the previous invoice.
Very good. And for the next one at 179, same comment, that probably did occur too.
Yeah.
Is that right?
Same comment.
Right. 180, capital A, a full-page advertisement in the Australian Worker for spring 05. Do you say that didn't occur?
It's highly unlikely we wouldn't have taken an ad in the Australian Worker at project level.
So you say it didn't occur. Is that your evidence?
I don't know whether it occurred or didn't occur.
Let me ask you again. You said earlier the reason we embarked on this exercise was you said if I took you to the invoices, you could say definitely which ones did and didn't occur.
I could give you comment as to the likelihood of whether they occurred or they didn't occur.
No, I'm asking you to clarify your evidence that you can say which ones did not occur.
I don't know whether this one occurred or not.
No. Page 182 is another invoice for the annual ball. And again, I'm sorry? Mr. Stolzer wants to tell me something. Oh, I'm sorry, it's a credit note. Yes, he's quite right. So now can I take you over to 191? You have that? Do you have that?
191, is it?
191.
Same comment as the previous invoices.
Just for the purposes of the transcript, I'll suggest to you that that's an invoice for training Heath Fletcher, and you don't say that didn't occur, do you?
I don't know.
You don't know if that occurred, but you can't say it didn't, can you?
I can't say where it did or it didn't. I don't know.
That's right, but I'm trying to test your statement on oath that if you looked at these invoices, you could say definitely which ones did not occur.
I can't say
And that's
whether it
not one-
occurred or it didn't occur.
No, so it's not one of the ones where you say that didn't occur. Correct?
I'm not sure which. I
think
can't say
he's
whether
answered
it
that
occurred
question.
or it didn't occur.
He's answered that question 4 or 5 times now.
Not in respect of that invoice, Commissioner.
Transcript will reveal whether I'm right or wrong, or you're right or wrong.
If the Commission please. Can you turn to 196, please?
Yes?
Tickets to the 2006 Industrial Relations Regulations Seminar. Do you say that didn't occur? Representatives of the joint venture did not attend that seminar.
At $23,000 for some tickets to an AW-led seminar is highly unlikely to have been something that the project procured.
So
But whether it occurred or it didn't occur, I can't tell you 10 years after the event.
No. Next page, 197. OH&S training for Barry Howlett.
Yeah, it's a pro forma invoice, so yeah, it's the same comment as applied to the
Same
previous
comment.
one.
You can't say that didn't occur either. And likewise 198 for training Joel Hurst. Correct? Is that correct?
Sorry, what's your question?
You can't say likewise for training Joel Hurst on page 198. You can't say that didn't occur.
No, as I said, that's the same comment that I previously made in relation to the...
All right. Well, there are a number of those, so let's see if we can shorten this. Wherever there's an invoice for training a named OH&S representative, you can't say as you sit there in that witness box that did not occur, can you?
I can't say whether it did or it didn't occur.
That's right. So it follows in particular, you can't say it didn't occur.
I can't say whether it did or it didn't occur.
You're not going to move from that answer, is that right?
I'm giving you an answer to your question.
And it's the case, isn't it, to try and shorten this process. Wherever there is an invoice for a full-page advertisement in the Australian Worker, you can't say that that advertisement did not appear, can you?
I object to that, Commissioner. One would really need to go to some of these invoices if this line is to be pursued, because, for example, the one on 207 is in a different category from some of the others.
I don't know that it is. The payment might be, but okay. Commissioner, whatever will best assist you, I'm happy to do. I'm happy to shorten this cross-examination as much as I can.
No, I think it's best if you conduct it as you see fit.
Commission, please. Page 198, capital A, please. You have that?
Yes.
An invoice for a full-page advertisement in the Australian Worker, Automo 6. Again, you can't say that that advertisement did not appear, correct?
The project wouldn't have required a $5,000 ad in the Australian Worker, but I can't tell you whether it occurred or it didn't occur.
At page 201, well, actually, it's most convenient to start at 202 because, as you know, emails read up the page. You see Mr. Mellum emailing Mr. Resnowicki breaking down an invoice. Do you see that? AWU ball 50 at 125, Australian Worker 4 at 7,500, sponsorship of the OH&S conference 25,000, OH&S training for HRS reps on Eastlink. Do you see those 4 cost centres broken down?
Yes.
And I think it's correct, is it not, that it was put to you in the private hearing that that breakdown was as a result of an invoice being refused payment by the joint venture because it was just the lump sum, 100,000 plus GST. Do you recall seeing that?
I recall some discussions about a $100,000 invoice being requested by Gillian to be given in 4 tranches,
Yes, to be broken down so that you could see where the money had
or
gone.
to be given in 4 tranches, not necessarily broken down, but given in 4 tranches.
Well, and you see that the 4 tranches are in fact for different services, are they not?
Oh, well, if that's the same thing as 4 tranches, that's correct, but that doesn't seem to me to be the same as 4 tranches.
Commissioner,
Okay.
I don't mean to keep interrupting, but there's just again a bit of confusion here. There's different sets of amounts. There was an invoice. There was initially 100,000 that was broken down, but that was broken down in a different way from this one. I just think my friend is entirely inadvertently, but is not putting the evidence quite correctly.
Yes, proceed, Dr. Hanscom.
Commission, please. Can you turn to page 204?
Yes.
Now, this is an invoice for places at the next year's annual AWU members' ball in 2006. You don't say company representatives didn't attend the ball, do you?
I can't recall.
In fact, Mr. Reznovitsky says he did go to the ball. Did you know that?
No, I didn't know
You
that.
didn't know that? In
I
fact,
did not know that.
no, he says he went to all 3 balls during the life of the project. Did you know that?
I did not know that.
Does that change your assessment of whether it's likely that tickets were purchased for the ball?
It doesn't change my answer, no.
Then you see at page 205, advertising in the Australian Worker, $33,000. Do you see that?
Yes?
Do you say that that advertising didn't occur? I accept that there's no detail given of the different issues.
There's no detail given, and it's highly unlikely to have occurred. $30,000 worth of advertising in the AWU magazine is highly unlikely to have occurred, and certainly wouldn't have been required by the project.
At page 206, there's sponsorship for an OH&S conference. You say that didn't occur. You did not sponsor an OH&S conference.
Again, the project wouldn't have paid out $25,000 for the sponsorship of an AWU health and safety conference.
So you're prepared to say that didn't occur as well?
I can't recall having been asked by Julian Rezonetsky for approval to donate $25,000, which he would have been required to bring to me to get my approval for such a donation.
All right. Page 206, big A, there's a reversal of the lump sum invoice for the Australian Worker. You see that?
Sorry, which page?
Page 206.
A?
And then
206A?
206A.
Yep.
And then at 207, it's re-invoiced. I don't think I need to trouble you with that because the amount's the same and your evidence would be the same, would it not? You would not have bought that advertising.
Well, the 2 invoices, different invoice numbers given on the same date for the same amount of money, $60,000 all up, for an ad in the AW magazine is highly unlikely to have been something that the project required,
Well, it's not.
or in fact could afford.
It's not 60,000, is it? Because it's invoiced and then reversed and then re-invoiced.
Oh, one's a tax credit, excuse me, yeah, okay, so one cancels the other,
That's right.
but not the previous one.
At 210, occupational health and safety training course, reps on Eastlink. You say that OH&S training didn't occur?
Sorry, which page are we on?
Page 210. Do you say that didn't occur?
I can't say whether that occurred or not, I can't recall, but again, I'd be highly suspicious that of that invoice. $33,000 worth of training is something that the project wouldn't have required to be given by the union.
Do you say the union never did any occupational health and safety training?
Not at the level of $33,000. Perhaps there might have been some safety rep training, given that it was evident by those previous invoices, perhaps, but not as a training organisation. If we needed that sort of quantum of training, we would have procured that external.
So does that mean you do say that the union did not engage in occupational health and safety training on Eastlink at any, shall we say, at any substantial level?
Not as indicated by that invoice of $33,000 worth of training in one go, no.
We don't know that it's in one go, do you?
We never contracted to the union to supply, $33,000 worth of training.
You're aware, aren't you, that unions do provide occupational health and safety training, and sometimes they do it through third-party providers?
That might have been the case, but
Are you
at
aware of
Eastlink
that?
on the project, we didn't require the union to provide that training for us.
That would be a matter within Mr Resniewicki's...
That'd be a matter for Gillian to assess and then come to me for approval.
Okay, he had to come to you for approval.
Yes.
What do you say his cost centre reporting limit was? At what point did he
I
have
can't
to
recall.
come to you?
I can't recall.
Did he have no discretion as to what he could contract with? How much he could contract?
He had a level of discretion up to a limit. Now, I can't recall what that limit was.
Well, do your best
In
if
regards
you
to
would.
health and safety training programs, they were consistent with a broader project strategy, and that strategy would have been approved by myself and would not have involved the union.
Can you do your best, please, to tell me what Mr Resniewicki's limit was as to what he could approve?
I'm sorry, say, what do you ask me?
Yes, I'll withdraw it and ask it another way if it helps. You were very firm a moment ago that he would have had to come to you to get the training approved at
Yes.
that level.
Yes.
That's your evidence.
Yes.
Remembering that, can you do your best, please, to tell me what his limit was that
I
he
can't
could
recall what
approve?
his limit was,
Well, then how are you confident that he would have had to come to you for approval?
because that's the nature of what he would have come to consult with me over.
I don't understand that.
Sorry.
What do you mean? That's the nature of it, because
The
it's so
nature of the provision of health and safety training is something that Gillian would have consulted with me as to what his proposal was, and therefore would have received my approval to that proposal.
There's something specific about OH&S training, is there, that affected what his limit was for approval?
No, it's got nothing to do with his limit. It's got to do with health and safety training generally and the program that we had in place and whether this program would have fitted into that overall strategy. But I do know that we wouldn't have gone to the union to procure health and safety training to the sum of $33,000 or any large sum of money such as that.
And what about having union representatives on site at inductions? You say that didn't occur as well?
The AW were in attendance at inductions, I think, yes, from memory.
Do you regard that as the provision of a service to the project?
I regard that as the union looking after its best interest. Its presence at inductions guaranteed it greater membership than what it would have been had it been just left to individuals to have been lobbied by the AW and the CFMU and join a union under those circumstances. Being present at the induction was something that was a clear strategy of ours and the AW to ensure that the AW's membership was maximised on the project.
Was a clear strategy of yours to ensure their membership was maximised?
Clear strategy of ours and the AW.
But in particular of yours?
Clear strategy of both. I don't think one was 60-40 or 40-60, it was 50-50. It was a strategy that both company and union adopted.
And that's because the AWU worked cooperatively on the project, isn't it?
That's in line with the strategy that we had from the beginning of the project, was that the AWU's presence on the project was to ensure that we didn't have CFMU dominance and therefore all of the industrial unrest that it was experiencing in Victoria at the time.
Do you resist the proposition the AWU work cooperatively with management on the project?
Yes.
That project came in 6 months ahead of time, did it not?
Thereabouts.
And it came in $100 million under budget, did it not?
No, did not come $100 million under budget. Sorry?
Okay. Did it come in under budget at all?
No, it came in a wee bit over budget.
How much?
Can't recall.
Okay. There was not one death on the project, was there?
No.
And it was a large project, wasn't it?
Yes.
There was not one serious injury on the project, was there?
We had a number of lost time injuries, but look, I can't recall the seriousness of each of those.
Mr. Ralph, construction projects are dangerous places, aren't they? You know quite well what I mean by there was no serious injury, don't you?
No, I don't know what you mean by serious injury, no.
Okay. Would you agree with the proposition that the standard of safety achieved on the site was unusually high for a construction project?
Yes, we put a lot of emphasis into it.
And would you agree that part of that was the cooperation and assistance of the union?
The safety outcomes were generally as a result of the safety programs that we had in place.
So does that mean you wouldn't agree? The union didn't help?
Union didn't hinder.
But it
They
didn't help.
they weren't driving the process. We were driving the process, and the union were cooperative in their participation when they were asked to participate, or in their support when they were asked to support.
So they didn't help. Your evidence is they did not help with that good safety record on that project.
They were part of the equation. I mean, safety outcomes is a result, good safety outcomes is a result of all of the stakeholders, including the union.
And it's also the case, is it not, that there was a very high level of flexibility with respect to things like rostered days off?
There was.
Can I finish the question?
Yes.
Compared with the sorts of agreements that were in place on other projects of commensurate size. Do you agree with that?
The agreement was certainly a new threshold agreement in Victoria compared to agreements up until that point in time, and delivered one of the primary objectives of flexibility, and that was around the roster days off, and when they were actually taken, what could be banked, and so on. The calendar, as it was put earlier.
Yes. And indeed, the so-called calendar didn't apply, did it? People were able to take their rostered days off in a very flexible way, and that assisted management, did it not?
That was one of the primary pieces or objectives of the industrialisation strategy right from the very beginning, to ensure flexibility so we could take greatest advantage of weather, particularly in open earthworks.
And the union agreed to it.
Yes, the union agreed. They signed the agreement.
You were in the hearing room when Mr Sass said that was the most important thing, not the level of wages, but the labour flexibility in terms of working days.
I was in the room when he said that. I don't necessarily agree with that sort of statement. It's a fairly sweeping sort of statement, but flexibility is quite critical.
Yes, and you got it.
Yes, it's a matter of record.
Did you ever have any discussions yourself with Caesar Mellom about industrial relations matters?
No. Julian represented the project in those discussions.
Excuse me, Commissioner, if you would. Commissioner, please.
Thank you. Mr. Cleland?
One matter, Commissioner. Thank you. Mr. Ralph, at the start of your evidence today, a transcript of a private hearing was tendered, and that hearing took place on the 18th of August 2015. Do you recall participating in that hearing?
Yes.
At that hearing, you swore to tell the truth, correct?
Yes.
You did so,
Yes.
to the best of your ability?
Yes.
You were asked a question. This is page 11 of the transcript, line 35, Commissioner. You were asked about your understanding of an arrangement involving payment of monies to the AWU, and you were asked in that context, did anyone ever suggest to you Mr. Shorten was involved in negotiating this arrangement? Your answer is recorded as no, and was that a truthful answer?
Yes.
Thank you. Nothing further.
Thank you. Mr. Stolzer?
Just one thing, Mr. Ralph, you were just asked some questions about a series of invoices. Can I just ask you to have a look at one invoice, the one on page 86, 186, sorry.
Yes.
Are you able to express any view on whether that work was carried out on behalf of the joint venture?
Again, I can't specifically recall. However, I would suggest that the project, again, where Julian, it being in Julian's area, would have come to me for approval for expenditure of this sort of money on that objective, and I'm fairly confident to say that we never spent money on the union undertaking a research on backstrain.
Nothing further. Thank you, Commissioner.
Excuse me, Commissioner. I have asked Mr. Stoljar to tender some issues, both original and photocopies of the Australian Worker. I don't know when he proposes to do that, but this witness would seem to be an appropriate time.
Well, I was proposing to do that. Dr. Hanscom raised this with me earlier on today, and I am proposing to do that, but I just need to look at it and put a bundle together in order to be able to do that. So I wasn't proposing to do it with this witness, but Dr. Hanscom can be assured I am proposing to tender them.
I'm indebted to counsel assisting for the assurance.
Any opposition to Mr. Ralph being excused from further attendance? Mr. Ralph, you're excused from further attendance on the summons, so you can leave the witness box now. Thank you for coming today. Have a good flight.
Tell us about time. What won't we do, Mr. Herbert?
Oh, sure. Sorry.
We could deal. You're not going to do that long, no? Yes, the next witness is Mr. Herbert, if Your Honour didn't mind sitting on a little bit after 4.
Don't mind that at all, if it suits Mr. Herbert's convenience.
Yes.
Do you swear by Almighty God that the evidence you shall give in this Royal Commission shall be the truth, the whole truth, and nothing but the truth?
I do.
Please have a seat, Mr. Herbert.
Could you tell the Commission your full name?
Christopher Parry Herbert.
You're a resident of New South Wales?
Correct.
You're a self-funded retiree?
Correct.
You had a private hearing in this Commission on 19 August 2015?
Yes.
I tender the transcript of that private hearing.
That will be known as Herbert MFI 1.
You've set out in that transcript your training, study and experience, so I won't take you to that. Can I just ask you about your involvement in the Eastlink project? You were the managing director of the joint venture.
Indeed I was. Just first I will make a comment. Please excuse my croaky voice. I'm just recovering from bronchitis.
But from the start of construction in early 2005, you were the managing director of the joint
Correct.
venture.
Right from the beginning.
And your position was taken over by Mr. Ralph in due
was.
course in about September.
Yes, I think he even mentioned earlier today the month he started, so that was it.
You reported to the Joint Venture Management Committee.
I did indeed.
There was a board above that, I told you.
Sorry?
There was a board as well of the joint venture.
There was the Joint Venture Management Committee, which had two John Holland and 2 Tees, and there's a supervisory board which was convened by Wal King, which would meet every second month, I think.
All right. Did you personally have anything to do with negotiating the EBAs?
No, I didn't. My task was sort of 100% focused on getting the job up and running, and the EBA, to my mind, was a corporate thing. That's where all the expertise and the practicalities lay. My job was to get the job going, and that in itself was a huge task.
Now, you said in your private hearing that you were not told at any time of any arrangement pursuant to which the joint venture would pay the AWU a sum of money each year.
Correct. As I mentioned in the hearing, the first I heard about it was when it hit the press, whenever that was.
All right, I want to put some evidence to you from Mr Resnevecki for your comment. He says that he did tell you about the deal at some stage. What do you say to that?
No recollection, sorry.
When you say no recollection, is it possible he told you and you've just forgotten about it?
Well, given, I'm going at 100 mile an hour to get staff together, to get design underway, to get everything, lots of things could have been said, and that's something that certainly didn't stick if it was said to me.
Wouldn't an arrangement like that stick in your mind?
Well, if we sat down and had a meeting about it, that this is what we propose to do, the answer would be yes. It was just something passing, and I didn't take any notice of, then the answer would be no.
Did you oversee his the expenses on his cost centre?
Sorry?
The HR cost centre, did you oversee or check those expenses?
Well, the answer really to that is no, and the costs seem to flow in after my time.
Well, just expand on that a little bit. I mean, costs would have been incurred in the early part of 05.
Oh, staffing costs only
Right.
in the early stage. Staffing costs are a different exercise to say, a HR direct cost or a safety or whatever.
Well, did Mr Resnevecki ever tell you at the time that there'd been some high-level discussions between the AWU and representatives of the joint venture concerning the possibility of funding an organiser?
If so, I certainly didn't take any notice of it. An organiser to me would be absolutely nothing. I wouldn't have given it any thought or consideration.
And did he say anything to you about the fact that, or whether or not an agreement had been reached before December 2004?
Agreement about an organiser or the EBA?
About the JV funding an organiser?
No, not as I would recall.
So you just say you got no memory one way or the other?
No, neither way. Neither way, that's correct.
I want to take you through some diary notes that have been provided in a volume that's been marked SAS MFI2. Do you have that in front of you on the desk, or if not, I'll provide you the copy.
Right, okay.
Now, Mr Resnevecki may say that in his evidence tomorrow that there was an understanding pursuant to which there would be the provision of support for the project by the provision of support through the funding of an organiser by the JV, but the dollar value of the support was not settled until later, until some point in March 05. And he has referred in particular to some diary notes, so I just want to take you through these diary notes and see if they jog your memory in that regard. If you have a look at page 23...
That's what's up on the screen?
Yes.
Yep.
You'll see that that is a note taken of a meeting on the 10th of December 2004. The attendees were, looks like, Stephen Sass, Don Johnson, Mike Connell and yourself.
Yes.
And sitting here today, do you have any memory of that
No.
meeting? When did you actually first start on the project?
I think it was about November when the project kicked off.
Right. So this is the following month.
Would be.
And somebody has made reference to two conveners employed by MFP. Do you have any recollection of that discussion or what that was about?
No, but it would just seem normal business.
Normal business in what respect?
If there were conveners being employed, conveners would be, I'm not sure what convener means. Union delegates, like I worked on the ABC project at Ultimo on building job, and you have union delegates. So it's.
Well, but did you have non-working delegates on this job?
I don't know the answer to that question.
Well, did this relate to a claim or request? To your memory, does this relate to a claim or request that the joint venture employ conveners and the... I'm sorry, yes, the joint venture employs some conveners?
It looks like a summary of points two conveners employed by MFP, right? That the two conveners would be employed.
But do I draw from that that you're really just drawing an inference from the language of the document. You don't have any memory of that?
No, none whatsoever.
And do you have any memory of that topic being discussed?
None.
The next document is a note of a meeting that you didn't attend. It looks as though the attendees were Mr Shorten, Mr Mellon, Mr Winter and presumably Mr Resnevecki, since it's his note. Did Mr Resnevecki or anyone else report to you about a meeting that had taken place on that day, or do you have any memory of that?
No, just the general reports. How's it going? My interest was getting with the EBA concluded so we could start work.
Well, it was a while before the EBA was concluded. It got bogged down in the AIRC. Is that right?
As people far more experienced in IR matters have said before me, yes.
So is your evidence you simply left all that to Mr Resnevecki, or first Mr
Very much.
Sass
He
and
was
then
a
Mr.
corporate expertise, as he and Julian Sass. It's an
Steve
area
Sass.
that I just don't have expertise in.
Well, just reading that note, there's a reference to 1 industrial officer and 3 organisers, 1 OHS. Does that ring any bells with you
No.
now? Doesn't refresh your memory in any way?
No, I'm sorry.
And just for completeness, on page 25, there's a further note of a meeting. Looks as though the attendees were Mr Mellon, Mr Johnson, Mr Connell and Mr Resnevecki. In other words, you don't appear to have been at this meeting. And again, there's a notation about an industrial officer, health and safety and 2 organisers. Do you see that? Down the bottom left-hand corner.
Right, see it, yeah.
Does that jog your memory at all?
No.
Mr Ralph was your successor as, well, he called himself project director, but anyway,
Correct.
or managing director of the joint venture. He said that he became aware of this and that to his mind at least, they were payments by the joint venture in return for the union's agreement to the EBA. Does that ring any bells with you?
None whatsoever.
Memory in any way? Were you aware of whether a dedicated organiser was deployed on the project?
No, as I said a little bit earlier, but I just wasn't close enough to industrial relations to know that. But, others on the team may well have been.
Nothing further. Thank you, Commissioner.
Yes, Dr Hanscom.
No questions, Commissioner.
Yes, Mr Cleland.
Commissioner, thank you.
Any opposition to Mr Herbert being excused? Mr Herbert, you're excused from further attendance on the summons. Thanks for your attendance today. Anything else we can do this evening?
No, Commissioner.
Hearing will resume at 10 a.m. tomorrow.